Good morning, Mr. Alexander. Morning. Morning.
Morning.
Okay, a lot of keys on my keyboard don't work apparently. So here's my phone number. I was going to explain what this was, but I was typing my phone number. So here's my phone number. If y'all get disconnected, and I'll send that out one more time when the competitors get in the room.
Kyle, are you from San Antonio?
Am I from San Antonio?
Mm-hmm.
I'm from south of there,
Okay.
from Divine.
Okay. Sorry, I hadn't seen a 210 in a long time. I was like, oh, okay.
Yeah, that's the closest city to where I grew up. So.
Okay. Yeah, I know where Divine is. I lived in San Antonio for 4 years, so I know where it is.
Yeah, the big city out there.
Yeah.
I don't think she was supposed to be in our room, but it looks like she left already. It's polls. Is everybody getting rain this morning? It's trying to start here. Got a couple of little drops on my car on the way over.
What's it like being in the law school?
It's nice. It's
Yeah.
nice. Quiet. Yeah. It's been a while since it's been.
That's what I was thinking.
We've walked into. Yeah. Okay, there we go. Good morning, Ms. Sahakian. Am I saying that right?
Yes, that's
All
perfect.
right. Okay, your second chair is in here, I think, already.
Perfect.
So we're just waiting on the other side. When the other side gets in, I'll put my phone number in the chat, just that way I don't have to do it a whole bunch of times in case we get disconnected.
Thank you, Your Honor.
Mm-hmm.
Have you had any issues with people disconnecting or no?
Not so far, not yesterday. I think we had one judge that was experiencing some pretty extreme weather and she dropped for about 2 minutes, but that was the only hiccup we had. And it was seamless because they're off camera, so.
Exactly, yeah. I mean, it's fine. I think even the advocates, when they get interrupted, if somebody drops off, you know, it's okay.
Yeah, as long as it's not a long time, I think it's pretty seamless.
Yeah. You almost have to go into it knowing that something is going to happen, you know?
Absolutely, absolutely.
Which is, by the way, not unlike real trial, even before Zoom. So always plan on that.
They once made us do a cross-examination in the dark because George Allen in Dallas was having rolling blackouts. So it was like, okay, we'll do it. And you adjust.
I feel like that would be extra good, extra pressure to put on the subject of cross-examination, a little drama.
It was not ideal. It was not ideal.
The funniest thing I've seen so far since the Zoom stuff started, we had a person in our courtroom show up in a wife beater. He was off camera, and then judge made him turn the camera back on. And I just would have lied at that point and said my camera doesn't work, but he turned it on, and he was in a wife beater. Excellent attorney.
Oh, it was the attorney.
That was the attorney. Yeah.
Oh, okay.
All right, so we had someone just join us. Okay, so Jackson is with us.
Yes, Your Honor.
All right, and then we just need Mr. White, and then we should be good to go. And I assume he's connected, Jackson?
Yeah, he should be right here in just a moment.
Sweet. We're waiting on one more competitor, but then we're good to go. Jackson, I'm going to ask if you're in close physical proximity to him, that you ask him to go ahead and connect. It's 10 now.
Yeah, unfortunately we're not in the same state at the moment, but I'll give him a call.
If you can shoot him a text.
Of course. One moment.
Thank you. Okay, here we go. There he is. All right, so Josh, I'm going to put my phone number in the chat one more time. If you'll get disconnected, that's the cell phone. So it is now 10. Fellow judges, you can turn your cameras off. We're going to go ahead and get started with the pretrial. All right, so we'll start. I can call the case if you want me to. You want me to call the case? Now calling the case of Jordan Gilmore versus Chimes Department Store, Inc. Counsel for plaintiff ready?
Good morning, Your Honor. My name is Joshua White. I, along with my co-counsel, Jackson Haddon, represent the plaintiff in the case, Mr. Jordan Gilmore. We have no motions in limine, but when Your Honor is ready, we do have a couple of non-substantive matters we'd like to address with the court.
Sure. And counsel for defense?
Good morning, Your Honor. My name is Rima Sahakian. I'm appearing with my co-counsel, Mr. Darshan Patel, and we represent Chimes Department Stores Incorporated. Your Honor, we do have a substantive matter as well as some housekeeping matters to address, so whenever the court is ready.
Okay, let's start with plaintiff's housekeeping matters. Go ahead, whenever you're
Yes,
ready.
Your Honor. First, plaintiff counsel intends to call our expert witness, Kelly Danes, to the stand by way of deposition. Pursuant to your pretrial order, her deposition meets the requirements of admissible former testimony under Federal Rule of Evidence 804A.
Okay, excellent.
And lastly, Your Honor, I did have an opportunity to confer with opposing counsel, and we did stipulate to a couple of exhibits for both parties. I'll just let you know what the exhibits that I'll be using are.
Sure.
Opposing counsel has agreed to pre-admit exhibits 2, 6, and 3. 6 and 3, Your Honor, we do intend to show during opening statements.
Excellent. And you don't have to ask me to publish those, just whenever you feel ready, or your second chair, I suppose. They're free to publish them as long as they're admitted. Okay.
And that concludes all of the plaintiff's motions.
Very good. Counsel for defense?
Your Honor, in addition to those exhibits, we also do have a couple more exhibits that we agreed to. Those are Exhibit 4, which is another photograph.
Okay.
Exhibit 10, as well as Exhibit 11.
Very good. So 4, 10, and 11.
Yes, Your Honor. We also agreed with opposing counsel regarding some substantive matters.
Okay.
We did stipulate that there will be no mention of any damages in this trial, as pursuant to Your Honor's pretrial ruling. This case has been bifurcated into a liability portion and a damages portion.
Very good.
Your Honor, there will also be no mention of a light switch that the defendant Chimes Department Stores added into their store after the accident has occurred.
Okie dokie. Anything else?
Yes, Your Honor, we have one motion in limine to raise with the court.
Go ahead.
Your Honor, this is a case about a realty company that breached its duty under a lease agreement to keep individuals in Chimes Department Store safe on their loading dock. This, coupled with the plaintiff's decision to climb the landing dock too quickly, led to the plaintiff's injuries in this case. Your Honor, our first motion is to exclude any mention of a previous employee's injury at Chimes, as well as Exhibit 14, that previous employee's statement regarding that injury. Your Honor, we move to exclude this evidence as substantially more prejudicial than probative under Rule 403. Evidence of this injury has low probative value because it occurred 9 years before the injury in this case occurred. Further, Your Honor, we have no information as to the conditions in which this injury occurred. It was during a time where Chimes Department Store was headed by a different manager than the one that's at issue in this case. And further, Your Honor, but certainly not least, Chimes will not have the opportunity to cross-examine the individual who was injured in the previous injury. And therefore, this is substantially more prejudicial than probative under Rule 403.
Okay, response?
Yes, Your Honor. As Your Honor is aware, the plaintiff has the burden of showing that the defendant, Chimes Department Store, did not meet a standard of ordinary care, and that breach negligently led to the fall suffered by my client. Now, if the defendant knew or had notice about any dangerous conditions and failed to act reasonably, it's important that the jury, as the trier of fact, has an opportunity to consider that. Exhibit 14 shows that Chimes was on notice of multiple dangerous conditions that contributed to Mr. Gilmore's fall. First, the area of concern in Exhibit 14 is the loading area at issue. Second, just like in this case, lighting conditions were poor. Third, there was also the same issue of accessing the light switch. 4, someone slipped on the same stairs. And 5, just like in this case, there was no railing near the stairs to grab onto. And to address opposing counsel's concern that there was a different manager at the time, well, as an offer of proof, their own witness will testify, Ms. Geller, who is currently the owner of Chimes, that she was fully aware of this prior incident, that she was fully aware of the conditions that were alleged, and that she decided not to act on them. And as far as cross-examining, Your Honor, we have a witness, Ms. Geller, if called, who can respond to any questions that opposing counsel has. She's their witness, and she is completely familiar with this prior incident.
Any brief rebuttal? I'll give you about a minute.
Yes, Your Honor. Based on opposing counsel's argument, then I would add that they are trying to use this evidence as character evidence to show action and conformity. That just because during this previous incident, the individual was hurt and the way that the management reacted is in conformity with the way that they acted in this case. And therefore, Your Honor, because this is a wholly different incident, occurred 9 years before, it is also substantially more prejudicial than probative.
Okay. I'm going to deny the motion in limine outright. So, you're free to raise the objection again when he tries to get it in. But yeah, I don't see this as character evidence, and I don't think the temporal nature of, being 9 years apart really moves my hand one way or the other on 403. So that's overruled or denied. And then we can go ahead and start with the opening statements. So the way I'm going to do it is I'll let you know after each time that you stop talking how much time you have left. If you'd like, once you get down to about 5 minutes, I can give you hand signals, 5, 4, 3, 2, 1. Do y'all prefer that or no? You want to do hand signals last 5 minutes?
Your Honor, yeah, if I don't imagine that we'll have an issue with timing. We've been doing pretty well on timing. Okay. So if it feels like it's an issue for you, please feel free to raise it. But my co-counsel has been helping with track.
Okay, if y'all don't need it, I won't do it. I won't distract. Okay, so let me put 55 minutes on the clock for plaintiff. And then plaintiff, whenever you're ready, whenever you start talking, I'll start timing.
Great. I'm gonna just change my view to speaker.
Sure.
Convenience first, safety second, responsibility last. The defendant, Chimes Department Store, had a railing removed from around the concrete platform and stairway behind their store. This made for easier access to unload merchandise. Convenience first. Then they ordered their employees to take their smoke breaks behind the store in the dark on a concrete platform using a stairway with missing railings. Safety second. On January 23rd, 2019, my client, Jordan Gilmore, fell off these stairs while taking a smoke break, lost his balance, and landed on his backside. Instead of having his back, the defendant is the reason he landed on it. Because in their eyes, in their pocketbook, responsibility comes first, or responsibility comes last. Now, my name is Joshua White, along with my co-counsel, Jackson Haddon. Well, we represent the plaintiff, Jordan Gilmore. Now, I don't have anything unusual to say about Mr. Gilmore. Before January 23rd, 2019, he would very ordinarily get up, go to work, and do his job. He isn't someone who people complain about, and he never expected to find himself sitting here asking his old boss to take responsibility for a fall he experienced at work. But today, that's exactly what he's doing. He's alleged that it's because of the negligence on the part of Chimes that he fell in the first place. Negligence, it's a legal argument. And I'll explain it more thoroughly at the end of trial. But for now, I just want you to keep in mind that this is a case about ordinary care, the kind of behavior that you should be able to expect from anyone. Now, today, the evidence will show that Mr. Gilmore just does what he's asked, nothing more and nothing less. He's going to take the stand today and talk a little about his routine. He's going to talk to you about a loading area located at the back of Chimes department store. Now, this loading area happens to be an area where a lot of activities happen. Right to the left of that loading area, or to the right of that loading area, you'll see a dumpster. And to the left of the loading area, there used to be a guardrail. Now that guardrail extended down the loading area and across the steps. It provided support and stability for people walking around that area. The evidence will show that Chimes asked to have that railing removed to make it more convenient for their delivery trucks to be unloaded. Now, as I mentioned, this loading area was used for multiple reasons. Take another look at that dumpster. It belonged to Chimes, and their employees were expected to use this loading area to throw out trash. Believe it or not, that wasn't the only use for this area. Today, when you hear from Mr. Gilmore, he's going to tell you that this loading area was designated as the only place employees were allowed to take smoke breaks. So employees like himself often found themselves in this area at least 20 times a week. Now, I mentioned the lack of a guardrail, but you might still be wondering why I'm focusing so much on this loading area. Today, the evidence will show that employees would often use this loading area at night. You'll hear the conditions described as pitch black. You'll learn that on January 23rd, 2019, there weren't any lamps outside lighting the area. Mr. Gilmore is going to tell you how that door right there would swing open, especially in windy conditions. Sometimes he'd have to walk around it because it would take up walking space, making his path in and out of Chimes limited and narrow. In addition to Mr. Gilmore, you're also going to hear from our expert witness, Kelly Dane. She's a professional engineer with a background in investigating cases just like the one you're about to hear. She's going to help you understand that ordinary care I was talking to you about a little bit earlier. She's going to tell you about some standards that we get from the Occupational Safety and Health Administration. You may have heard them referred to as OSHA. The evidence will show that what these standards require and what Chimes provided aren't one and the same. Now, I want to prepare you for what you can expect to happen during the course of this trial. I'm going to spend a lot of time talking to you about who was in control of the loading area and who was responsible for what happened there, because answering these questions will be important at the end of the trial when you're asked to determine who is liable for Mr. Gilmore's fall. Now, today, the plaintiff is going to provide you with evidence that shows that the only person who has exercised or exhibited any display of control of the loading area is the defendant. If you can remember, that last picture I showed you, I want you to visualize that giant dumpster you saw. That dumpster was in the loading area. That dumpster belonged to Chimes. The evidence will show they ordered it. It will also show that they never asked anyone, including their landlord, for permission to put it there. They never even notified their landlord that it was there. When this trial concludes, the facts you're allowed to consider will show that Chimes didn't just have knowledge that their employees, including Mr. Gilmore, regularly use the loading area, they required them to. Today, Mr. Gilmore is going to tell you firsthand that on January 23rd, 2019, he lost his balance. He lost his job, and he lost his dignity. Today's trial is an opportunity to determine who is responsible. At the end of this trial, myself, along with my co-counsel, Jackson Haddon, we're going to ask you to return the only verdict supported by the facts, the only verdict justified by the evidence. We'll ask you to find the defendant, Chimes, liable for negligence. will ask you to tell them that you can't put convenience first, safety second, and responsibility last.
Opening statement on behalf of the defense, Your Honor.
Yes, that was 48:30 remaining. Give me 1 second to reset the clock. Okay, 55 minutes on the clock. When you start talking, I'll start timing.
Members of the jury, what happened to Mr. Gilmore was unfortunate. No one in this courtroom denies that, especially not Chimes department stores. Our hearts go out to Mr. Gilmore for the injury he suffered. But when accidents like this happen, we can't just focus on what happened. We also have to focus on why it happened. And today you'll learn that the why behind the what is clear. Because Kermit Realty Group was the one who was in charge of maintaining and making sure that landing dock was safe. And the plaintiff, knowing that landing dock wasn't safe, rushed to climb that landing dock in the dark. Because hasty decisions lead to harsh consequences. Now, before we talk more about this case, I want to talk a little bit about the men and women at Chimes department stores. People like Reese Geller. Miss Geller, will you please turn on your camera? Members of the jury, this is Reese Geller. She's the owner of Chimes department stores, or Chimes as most people like to call it. She's been with the company for her whole career. And Chimes, well, it's not one of those big luxury department stores like Macy's. It's a lower end, family-owned business. Miss Geller has been working hard to make sure that her family trusted her to take over this company and continue the excellent service that they've had for years. Thank you, Miss Geller. But as you just heard, the plaintiff is claiming that Chimes failed to maintain their loading dock, causing the injuries to Mr. Gilmore. But as Judge Gardner will tell you, in court, the plaintiff can't just make claims, they have the burden to prove them. And today they'll fail to meet that burden because instead the evidence will show two things. First, that Chimes wasn't even the party responsible for that loading dock. And second, that it was the plaintiff's own choices that led to his injury. So let's talk about that first thing the evidence will show, that Chimes wasn't even the party responsible for taking care of that loading dock. Today, when Miss Geller takes the stand, she'll tell you how she came into the lease for this property. And she'll explain to you how she negotiated the terms with Kermit Realty, and how both parties understood their obligations under the lease. In fact, she'll point to you where Kermit Realty took possession and power over that loading dock, because that loading dock is in an area known as a common area, which is controlled by the landlord of the property, not by the tenant. And you'll hear that as an experienced landlord, Kermit Realty knew that it was their job to make sure that anyone on that loading dock making use of that loading dock was safe. Now, you're also going to hear from an officer from the Occupational Safety and Hazard Administration, Perry Hayden. You're going to hear his deposition testimony. And Mr. Hayden is going to tell you that those regulations that the plaintiff just mentioned, well, none of them apply to loading docks. You're actually going to hear that Perry Hayden went to Chimes department store in 2018, months before this incident occurred, and actually conducted a regular inspection as required by OSHA. You're going to hear Mr. Hayden didn't find that Chimes was in violation of any guidelines or any standards. he didn't even issue them a warning or a citation. That's because OSHA values the opportunity that these business owners have to use that loading dock and be able to put in their items and be able to make use of the loading dock. So that brings me to the second thing the evidence is going to show, that it was the plaintiff's decisions that led to his injuries. Members of the jury, but to understand that, we have to go back to the day of the accident. The plaintiff's gonna tell you that he went outside to take a smoke break with his coworker. And when he stepped outside, he realized it was dark outside because the sun had already set and the light that was used for the outside, well, that light was off and this wasn't anything new. The plaintiff himself is going to admit to you that he knew that light was off regularly. But despite knowing that that light was going to be off, despite knowing that those stairs didn't have a guardrail to hold on to, despite knowing that there was a door that was going to interfere with his chance to go up those steps, the plaintiff rushes up the steps, which causes him to fall and suffer the injury in this case. Members of the jury, hasty decisions lead to harsh consequences. And that's just not Chime's fault. That's why at the end of this trial, I'll come before you and ask you to find the only just verdict, the only fair verdict, a verdict finding Chimes not liable.
Okay. 48-45 remaining. Okay. Let me reset your time, plaintiff, and then we can have you call your first witness. Okay. So 48:30 on the clock. Plaintiff, whenever you're ready, you can call your first witness.
Your Honor, plaintiff calls Mr. Jordan Gilmore to the stand.
Okay.
Good afternoon, Mr. Gilmore. Please introduce yourself to the jury.
Okay. Hold on. I'm not seeing Mr. Gilmore. Give me one sec. Mr. Gilmore, witness. There we are. Okay. Gonna go ahead and let's take two. We'll start that over.
Good afternoon, Mr. Gilmore. Please introduce yourself to the jury.
My name is Jordan Gilmore.
Mr. Gilmore, where do you live?
I live in Waco, Texas. It's right here.
I'd like to start by helping the jury get to know you a little bit better. What do you do for a living?
So right now I'm unemployed, but I did work at Kimes for 10 years as a cashier.
What is Chimes exactly?
So Chimes is a local department store here in Waco. It's like Macy's, a little bit lower end, but it just, sells a little bit of everything. So clothes, jewelry, the whole 9 yards.
What was your position?
So I was, like I said, I was there for 10 years and I was a cashier most of the time.
Now, you just mentioned that you previously worked there. Why aren't you there now?
So I was let go after, so like I said, I was there for 10 years. And then after I hurt my knee, I couldn't work for a while. And while I was out, they hired someone to replace me. And then there was just nowhere for me when I came back, I guess. So
how long had you been working at Chimes?
10 years, so quite a while.
Now, Mr. Gilmore, I want to turn your attention to January 23rd, 2019. Can you tell me what happened that day?
Yes, that is the day I was injured while I was working.
Around what time did that occur?
It was around 7 p.m. at night.
Was the sun still out?
Yeah, no, it was actually pitch black. It was very dark.
Were there any street lamps to help you see?
There was a street lamp, but it wasn't turned on, so it was pitch black outside.
How was the weather?
So that night, I remember it was pretty cold and windy, so it was pretty bitter. for Waco, definitely pretty bitter.
So you mentioned you're outside. What were you doing at the time?
I was smoking.
And Mr. Gilmore, I have to ask, is that allowed?
Yes, so we are able to take smoke breaks, and so I was just taking a little smoke break out back.
Mr. Haddon, referring court and counsel to what's previously been admitted as exhibits 2 and 3, Mr. Haddon, can you publish? Mr. Gilmore, do you recognize these?
Yes, so that is where I was smoking at. That's the back of the building.
And can you explain why were you smoking in this area?
So we were instructed to go back there by my boss. I had to smoke back there basically.
On average, how many times a week would you say that you would go in this area?
Probably 20 times a week. It's quite often.
Did you do anything in that area other than smoke?
Yeah, so you can see the trash can right there. That's also where we would take the trash. And so I'd have to go out and take trash there as well.
Now, I'd like to discuss the fall that you mentioned. Was anyone with you at that time?
Yeah, so I went out back with my coworker, Riley.
And where were you specifically located outside?
So I was at the bottom of the stairs. So I was at the bottom.
And after you made it down the steps, what happened?
So I smoked my cigarette and just took my break.
Now, was there any railing or anything to hold on to that you might have been able to use as you were going down the stairs?
No, so I kind of hung onto the wall a little bit just for stability, but there was no railing or anything like that.
Now, you mentioned that after you finished smoking, you started to go back up the stairs. What happened at that time?
So just like I came down, I kind of held to the wall to walk back up, and my coworker Riley, she was holding the door open for me, and so I kind of had to walk around it a little bit to get back inside, and that's how the accident happened. Is when I was trying to get around the door, I fell.
Mr. Gilmore, why was your coworker holding the door?
So I can get back inside. So she was. Sorry, go ahead.
Can you describe how that door worked?
Yeah, so the door swung all the way open, like it was a swinging door, and so it could go parallel with the wall. But the problem is it was just really windy, so she was holding it, so it wouldn't like blow open and hit me basically. So she's just kind of keeping it in place so the wind didn't catch it.
Was there a manager on duty that night who might have been able to help you?
Yeah, so Miss Kim, Lane Kim, she was the manager on duty that night.
How did she respond?
So she, we told her after the accident, she, recognized that, yeah, we probably should have put some railing or something so that didn't happen. But otherwise, it's kind of dismissive, just, deal with it.
Mr. Gilmore, I'd like to just clarify a couple of last points. Had anyone told you not to go out back?
No.
Had anyone ever instructed you that doing so was unsafe?
No.
Had anyone told you that someone other than Chimes was responsible for this area?
No.
Did you have any reason to think someone other than Chimes was responsible for this area?
No, sir.
Your Honor, we passed the witness.
42:33 remaining. Give me just 1 second to reset your clock for cross. Okay. 48:45 whenever you start talking.
Mr. Gilmore, on the night of your accident, you weren't a new employee of Chimes department stores, right?
Yes, that's right.
In fact, you had been working there for 10 years.
Mm-hmm. Yeah.
All of those years in the same location.
Yes.
During those 10 years, you always took smoking breaks.
Yes.
At least one a day.
Mm-hmm. Probably, yeah.
You took those breaks in the back of the store by the loading dock.
Yes.
And you also went out to the loading dock to throw trash in the dumpster.
Yes.
Like you mentioned on direct, you do that once or twice a day.
Mm-hmm. Yeah.
So you'd estimate you were out on the loading dock about 20 times a week.
Yeah.
In your own words, You were pretty familiar with the area.
Yes.
But on the night of your accident, you were getting off of a long workday.
A normal work day.
Well, you had been working since noon, right?
Yeah. So 8-hour shift.
And you weren't getting off until the close stored at 8, like you just said.
Yeah.
By 7 o'clock, you needed that smoking break.
I wanted it, yes.
And you knew it was cold outside.
Mm-hmm.
Is that a yes?
Yes.
And windy.
Yes.
And so you were just going to smoke and then get back inside quickly.
Yes.
And you didn't plan on being out there for very long.
Yes.
You knew that the light wouldn't be on outside.
Yes.
In fact, you can't recall a single time that light was ever on.
Right. Yeah. It's never on.
But despite that, you didn't choose to go smoke in your car,
No, I didn't.
even though you had smoked in your car on your lunch breaks before.
Yes.
You also knew there wasn't a railing out there
Yes.
because there never had been a railing for as long as you had worked there.
Yes.
You never complained about the lack of a railing.
No.
And because it made sense to you that a loading dock wouldn't have railings.
Yeah. And I just never thought about it really.
Well, that night you walked down the stairs to smoke at the bottom, right?
Yes.
And you never had any problems getting down those steps.
No.
Then you would go back up the stairs.
Yes.
You had never had problems going back up those stairs before either.
No. I walked up them just fine.
But on this night, your coworker Riley came with you to smoke.
Yes.
And Riley was standing in the middle of those two doors that lead outside to the loading dock.
Kind of, yeah.
And Riley was blocking some of the light coming through that door.
Yes.
But you didn't ask Riley to move so that you could open the door fully.
Yes, I did not ask her to move.
You didn't ask Riley to open the second door to let in more light.
Well, I don't think she could have because of the wind, but no, I did not ask her to open the second door.
Well, you didn't bring a cell phone to use as a flashlight either.
No, I'd never needed one.
Well, you didn't ask Riley to use her cell phone either.
No.
You mentioned that you didn't need one even though it was pitch dark outside in your own words.
Yeah.
Instead, you claimed that on that night, you had to put your hand on the wall to steady yourself.
Oh, yeah, I usually did.
Well, in your deposition, you say you did that multiple times.
Yeah.
But you also gave a statement to your employer about the accident.
Yes.
Your Honor, referring court and counsel to what's already been pre-admitted as Exhibit 10. Mr. Patel, will you please publish Exhibit 10 for the jury? Mr. Gilmore, this is that statement you gave to your boss after the accident.
Yes.
At the bottom of the first page, you describe in detail how the accident happened.
Mhm.
Is that a yes?
Yes.
And now nowhere in that description do you mention using your hand to steady yourself.
Yeah.
And in that statement, this statement was given just 2 days after the accident.
Yeah.
And the first time you mentioned the hand on the wall was in June 2020 when your deposition was taken for this lawsuit.
Mm-hmm.
Is that a yes?
Yes.
Almost a year and a half after the accident.
Yeah.
Now, as you were reaching the top of the stairs, you realized your path to the landing at the top was blocked off.
Mm-hmm.
I'm sorry, Mr. Gilmore.
Yes.
I
Yes.
need a yes for our court
Yes.
reporter. Thank you. That's because Riley was standing in the doorway holding the door open. That's why the path was blocked.
Yes.
But the door, it wasn't fully open.
No.
It was only partially open.
Yes.
And so it was blocking your way.
Yes.
Mr. Patel, will you please post what's been already admitted as Exhibit 4? And Mr. Gilmore, that's what that door looked like, right?
Yeah. Something like that.
But you didn't ask Riley to move.
No.
You didn't ask her to open the door fully so that you could get by easily.
No.
Instead, you decided to maneuver to go around the door.
Yeah.
And when you did that, your foot slipped.
Mm-hmm.
You knew you were going to fall to the ground.
Well, yeah, I mean, I was falling backwards, yeah.
So that's when you decided to jump.
Yeah.
And
I had to.
that's when you fell, injuring yourself.
Yes, when I fell off the landing dock is when I injured myself.
Thank you, Mr. Gilmore. Your Honor, no further questions.
4221 remaining. Any redirect for this witness?
Yes, Your Honor.
Okay, give me 1 second to reset your time. So 4233, whenever you start talking.
Mr. Gilmore, during your 10 years of employment at Chimes, did anyone at Chimes tell you that what you were doing was against the rules?
No, they told me to do it.
During your 10 years at Chimes, had anyone told you that what you were doing was unsafe?
Objection, Your Honor, vague.
I'll hear it. I mean, what was vague? Explain that argument.
Your Honor, the question was, did anyone at Chimes tell you what you were doing was not safe? That the concept of what was he doing with regard to what?
Just rephrase the question to something more specific, Mr. White.
Yes, Your Honor. Mr. Gilmore, you understand that we're talking about the loading area.
Yes.
Now, did you ever move around the loading area?
Yes.
Did you take smoke breaks in the loading area?
Yes.
Did you ever do
Objection, Your
work?
Honor, leading.
Try not to lead the witness. Ask open-ended questions. This isn't a cross. You can resume.
Did you ever move around the loading area?
Yes.
And during your 10 years at Chimes, did anyone ever tell you that how you moved around the loading area was unsafe?
No.
Had anyone ever told you that what you did in the loading area was unsafe?
No.
Did anyone provide you with safety training on how to move around the loading area?
No.
No further questions.
4123 remaining. And just to clarify, we're stopping the time each time an objection comes up. I know y'all know that, but I just want to make that clear. Okay, so your next witness, Mr. White, or anything further from this witness?
No, Your Honor, may this witness be excused?
He may. Thank you.
Your Honor, at this time, the plaintiff would like to call, by way of deposition, Kelly Danes to the stand.
Okay. Excellent.
Your Honor, permission from my co-counsel to appear.
Of course.
Morning, Your Honor.
Good morning, Mr. Haddon.
So, Your Honor, as we read through this deposition, we'll be sure to give record citations so that Your Honor and opposing counsel may follow.
Excellent. Whenever you start talking, I'll start timing.
Beginning at page 80 of the record, starting at line 12. Tell us about your education.
I have a Bachelor's of Science in Mechanical Engineering from the University of Wisconsin-Madison.
Page 80 of the record, starting at line 24. I noticed that your CV lists you as a PE. What is that?
It stands for Professional Engineer.
What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the Fundamentals of Engineering exam, which I did. Then you work as an engineer for 4 years before you take the Professional Engineering exam. So I took that as well and I passed.
Page 81 of the record, line 13. What do you do professionally?
I'm the president of Danes Engineering LLC.
What does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Page 83 of the record, line 14. All right, Kelly, I want to move on and talk about your work in this case. What did you review in coming to your opinions in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Page 86 of the record, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
Page 87 of the record, line 9. All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS section 654, and the maintenance provisions under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards. So, fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
Page 91, line 5. Do you know when the guardrails were removed from those stairs?
No, and I don't know who had them removed. All I know is that at one point they were there, and by the time of this incident took place, they were gone.
Couldn't the person walking up those stairs have just used the wall to steady themselves and stayed away from the exposed edge of those stairs?
I mean, I suppose that would work, but that's not the question. The bottom line is that those stairs needed guardrails in order to meet code requirements, and they didn't.
No further questions, Your Honor.
3731 remaining. Okay. Are you going to be doing any cross of this deponent?
Yes, Your Honor.
Okay. Let me get your time back up. 4221. I'm assuming your co-counsel is going to be reading.
Yes, Your Honor.
Excellent. Okay. Whenever you're ready to start, I will start timing.
Starting on the bottom of page 3, line 22. Question. Based on what you do for a living, is it fair to assume that you regularly testify in lawsuits?
Yes, no question about it. I testify and work as an expert on cases on a regular basis. To be honest, preparing expert opinions in lawsuits like this one, testifying in depositions, and testifying at trials are about 99% of what I do at this point.
Have you ever worked in code enforcement at any level of the government?
No, I've always been in private practice.
How'd you get involved in this case?
I got a call from the firm representing the plaintiff, Jordan Gilmore. It's a firm I've worked for in the past, so this isn't the first time that I've consulted in one of their cases.
Continuing to page 5, line 3. Kelly, I'm showing you what's been marked as Exhibit 15. Do you recognize this?
Yes, it's the invoice for the work that I've done so far in this case, which obviously doesn't include my time today or time for testifying at trial if I have to do that.
Moving on to page 9, line 4. Do you know or have any opinion on who is responsible for the maintenance and repair of these steps behind the chime store?
No, that's not what I was asked to do. I assume it was Chimes, but that's just a guess.
Moving on to page 10, line 19. Do the OSHA regulations place any requirements on employees?
Yes, there is a general duty requirement in 29 USCS section 654B, which says that employees also have to comply with OSHA standards and regulations and basically have to be responsible for their own actions.
Page 11, line 20. Have you ever seen that light above those stairs turned on at night? Do you know how much light it would have provided?
No, I've never seen that. I just know that it wasn't on and there was no switch for it.
And page 14, line 12. You would agree, though, that this area was used by Chimes as a loading dock at times.
Yes, at times.
And a guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock.
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
Your Honor, that concludes our reading of this witness's deposition.
Okay. 39, 31 remaining. Anything further from plaintiff?
Your Honor, at this time, the plaintiff concludes its case in chief.
Okay. I'm assuming we can just move into defendant's case and we can take a comfort break before closings if we need that. Is that okay with everybody?
That's fine, Your Honor.
Okay, so let me get your, well, I've already got you set. 39, 31 remaining. You can call your first witness, defendant.
Your Honor, defense calls Reese Geller.
Yeah. Let's just wait for them to show up on the screen before we start. Ms. Geller?
I think it takes a moment for them to change seats.
There we go. You've been previously sworn, Ms. Geller. Whenever you're ready.
Good morning. Please introduce yourself to the jury and tell us where you live.
Good morning. My name is Reese Geller and I live in Waco, Texas.
Tell us your educational background.
I graduated from Baylor in 1998.
What do you do for a living?
I am the owner of Chimes.
What's Chimes?
It's a mom and pop department store, kind of like a JCPenney or Macy's.
Now, have you always been the owner of Chimes?
No, it was originally started by my grandparents, but I worked my way from the bottom up.
Well, how long have you worked at Chimes?
I worked at Chimes since I graduated from college.
Would you say that it's about 10 years?
Yes, about that.
Now, let's talk about why we're here today. Are you aware of an accident that occurred at Chimes on January 23rd, 2019?
Of course.
What happened that day?
One of my workers fell and injured himself.
Do you remember who it was?
Yes, it was Mr. Fuller.
Was it Mr. Fuller or was it Jordan Gilmore?
Gilmore, sorry.
Now, where did Mr. Gilmore fall?
On the loading dock.
To the best of your knowledge, who's responsible for maintaining that loading dock?
Kermit Realty.
Who's Kermit Realty?
That is the company that we lease the property from.
So why do you say that Kermit Realty is in charge of maintaining that dock?
Because in our lease documents, they were in charge of the common areas, which included the loading docks.
Your Honor, I have the lease agreement, which has been already admitted as Exhibit 11. Mr. Patel, will you please publish Exhibit 11 for the jury? Ms. Geller, are you able to see that okay?
Yes.
Now, looking at section 6.3 of this lease agreement, what does this lease agreement say about who is responsible for maintaining the loading dock?
It says that the landlord is responsible.
And looking at section 6.1, I know in 6.3 it references common areas. Does 6.1 define what a common area is?
Yes, it includes the loading areas.
Thank you, Mr. Patel. You can take down Exhibit 11. Now, let's talk about the structure of the loading dock. Are there any guardrails at that loading dock?
No, there's not.
Were there guardrails at any point?
There used to be.
When was that? Do you remember?
Around 2005.
Well, if there were guardrails in 2005, who removed them?
Kermit Realty did.
Why'd they remove them?
They removed them at our request because we wanted to transform the area into a loading dock for our store.
Well, Ms. Geller, then why didn't you just leave the guardrails on the loading dock?
Because that would defeat the whole purpose of the loading dock and it wouldn't allow us to best use it as a loading dock.
Well, were you trying to make it unsafe for your employees by removing the railing?
No, we were just trying to do what was best for our property and our store.
Now, what safety procedures does Chimes have in place for employees?
We asked all employees to notify us if they had any concerns about anything regarding to safety.
Now, to the best of your knowledge, who owns the land where Chimes is located?
Kermit Realty.
Who did Chimes enter the lease agreement with?
Kermit Realty.
And based on your understanding of the lease agreement, who must Chimes ask for permission before making any changes to the common areas?
Kermit Realty.
Thank you, Ms. Geller. Your Honor, no further questions at this time.
35:21 remaining. Give me 1 sec to reset your time for cross. Okay. So 37:31, whenever you start talking, Mr. White.
Good afternoon, Ms. Geller. I'd like to start by discussing what it is that you do for a living. You mentioned on direct examination that you're the owner of Chimes Department Store.
Yes.
It's located right here in Waco, Texas.
Yes.
Working at Chimes is what you've done your entire career.
Yes.
You started out as a buyer,
Yes.
and now you're the boss.
Yes.
And that's not too surprising.
No.
I mean to say that Chimes is a family business started by your grandparents.
Yes.
Now, you've been the boss for 10 years.
Yes.
Let's talk a little bit more about Chimes. So it's a department store.
Yes.
And you sell shoes,
Yes.
clothes,
Yes.
tools,
Yes.
among other things.
Yes.
Now, you mentioned that in 2005, Chimes moved into the location that you're at now.
Yes.
That's because you needed more space.
Yes.
Now, you helped negotiate the current lease with your landlord, Kermit.
Yes, I did.
And as you mentioned, you're aware that according to the lease, that there are certain areas you have access to, but no control over.
Yes.
There are also areas that you do have control over.
Yes.
And as you mentioned, those areas are called demised premises.
Yes.
And there's a site plan that specifies which areas are not under your control and which areas are.
Yes.
Now I'd like to talk about the area behind Chimes.
Yes.
Mr. Haddon, can you publish what's already been admitted as Exhibit 2? Now, this is the loading dock and the surrounding area, isn't that right?
Yes.
And they're not a part of the demised premises.
No.
So per the contract, they were under the control of the landlord.
Yes.
But you'd agree that Chimes had some control over that area.
We used the area, but I wouldn't say that we controlled it.
Well, isn't it true that Chimes ordered a dumpster?
Yes, but we weren't altering the property in any way by doing that.
So you did order that dumpster.
Yes.
You placed that dumpster in an area that was not specified as under the control of Chimes.
Yes.
It was specified as under the control of Kermit,
Yes.
but you never let them know about that dumpster.
No, because we weren't altering the property, so we didn't think that we had to underneath the lease.
So you never let them know?
We did not.
Now, there were no guardrails on the steps of that area.
No.
And that's because you asked your landlord, as you mentioned on direct examination, to remove them.
Yes.
Well, let's discuss how Chimes responds to safety issues. You instruct your employees to let you know if there are any safety issues.
Yes.
And you do this because you care about their safety.
Yes.
You've had an employee report safety issues around this loading area in the past.
I don't recall.
Would seeing statements that you've previously made help refresh your memory?
Yes.
Referring court and counsel to page 104 of the record, lines 16. And Ms. Geller, if you could look at page 104 of the record and just read starting at line 16 through page 105, line 2, and just read that to yourself. And once you finish, let me know.
Yes.
Now, as I mentioned, you've had an employee report safety issues around this loading area in the past.
Yes.
Referring court and counsel to what has been previously marked as Exhibit 14 for identification, let the record reflect. Opposing counsel has a copy. Ms. Geller, can you pull up a copy of Exhibit 14 in front of yourself? And that's on page 164 for your reference.
Okay.
Now you recognize this.
Yes.
It's an interview statement made by Jason Stiles.
Mm-hmm.
Is that a yes?
Yes.
And you recognize this statement because he was an employee.
Yes.
And this is an accurate copy of that statement.
Yes.
Your Honor, plaintiff moves Exhibit 14 for identification into evidence.
Any objection?
Your Honor, we would re-raise our objection under Rule 403.
Okay, I'm going to overrule that objection, and it is admitted.
Ms. Geller, you're aware that Mr. Stiles reported that the loading area was dark.
Yes.
You're aware that he asked about a light switch.
Yes.
And you also know that he was told by a supervisor that the light switch was next door
Yes.
and that nothing could be done about it.
Yes.
He says that as he was walking down the stairs, he fell face first.
Yes.
He also noted that there was nothing for him to grab onto.
Yes.
Now, you were made aware of all of these concerns on January 8th, 2010,
Yes.
but you didn't address his concerns.
No.
And that's because that would have been Kermit's job.
Yes.
So after this incident, you reached out to Kermit and asked him to put a guardrail next to the stairs.
No.
Well, after this incident, you reached out to Kermit and asked him to provide some lighting.
No.
Well, you at least reached out to Kermit and asked him to inspect the loading area for safety.
No.
Now let's talk about your current workers. Your workers were familiar with the area behind Chimes.
Yes.
And they used that area a lot
Yes.
because they needed to use it.
Yes, for the loading purposes.
Yeah, they needed to use it to do their job.
Yes.
And they received deliveries here almost daily.
Yes.
They also use this area to dump trash.
Yes.
You'd agree that you're responsible for your employees?
Yes.
You're in charge of their work?
Yes.
And you have to reasonably ensure their safety?
Yes.
But Chimes never inspects anywhere inside or around the store for safety issues.
Yes.
Is it your testimony that Chimes does inspect inside and around the store for safety issues?
We tell the employees to look out and notify us if they see anything wrong.
That's right. You leave that responsibility with your employees.
Yes.
No further questions.
30 minutes and 5 seconds remaining. Give me 1 second. Any redirect for this witness?
Yes, Your Honor.
Okay, let me reset your clock. You've got 35:21. Whenever you start talking.
Ms. Geller, who is in charge of determining whether you can make changes to the loading dock area?
Kermit Realty,
And why is that?
because that is underneath their control under the lease.
Thank you, Ms. Geller. Your Honor, no further questions for this witness. May she be excused?
She may. 35:03 remaining. Okay, you can call your next witness.
Your Honor, defense calls Perry Hayden by way of deposition.
Excellent.
Your Honor, I will be looking at my second monitor to read, so I'm not just looking off into the distance.
I'm gonna allow it.
Thank you, Your Honor. Beginning on page 2, line 5. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
Line 11. What do you do for a living?
I'm a compliance, safety, and health officer with the Occupational Safety and Health Administration.
What does the Occupational Safety and Health Administration, or OSHA, do?
Well, OSHA is a government agency that is responsible for making sure that workplaces are safe for the employees that work there. So we provide information, training, and assistance to employees and employers to try and make the workspaces as safe as possible and to make sure those workplaces are in compliance with OSHA regulations and standards. We're all about employee safety.
And what do you do at OSHA as a compliance, safety, and health officer?
I'm one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
Moving on to page 3, line 4. What happens if a workplace doesn't comply with OSHA standards?
Well, there are lots of potential implications, but at the very least, it would result in a citation for any violations that we find.
Line 16, how long have you been working for OSHA?
Since I got out of school. So at this point, that's about 13 years.
And over that time, how many inspections have you conducted?
Oh man, hundreds, thousands? I mean, the answer is a lot. It's basically my entire job. So I'm always out on the road inspecting somewhere. It's an everyday thing.
What kind of an education did you receive before becoming an inspector for OSHA?
I graduated from high school and then I went on to Texas State Technical College where I got an associate's degree in occupational safety compliance technology. Then I went on and got a second associate's degree in environmental technology compliance.
Page 4, line 5. What are those degrees about?
Well, there are really training programs dealing with the hazards of machines, safe work methods, environmental hazards, workplace hazards, and various safety issues. These are literally the degrees you need if you want to do something like work for OSHA.
Have you ever testified in a lawsuit before?
No, first time.
How'd you end up being involved in this case?
I got a subpoena from you and it told me to show up here. So that's what I did.
Page 5, line 1. Are you being paid by anyone for your time today?
Nope.
All right, Mr. Hayden, how are you involved in this case?
Well, I conducted an inspection at that Chimes department store in Waco back in 2018. So I assume that's why I'm here.
And why did you inspect the Chimes department store in Waco back in 2018?
It was just a regularly scheduled inspection. We do that all the time. Just show up and do an inspection.
So were there any complaints that led to this inspection?
Not that I'm aware of.
During that inspection, what were you looking for?
Well, at the most basic level, I'm looking for any kind of condition at the workplace that might be dangerous to the employees working for Chimes.
Page 6, line 8. Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Did you inspect the area behind the store where there's a little landing area and some steps?
Yes, I did.
Why did you inspect that area?
The manager at Chimes that day told me that employees regularly worked in that area behind the store and took smoke breaks there. So once I had that information, I made sure to include it on my list of areas to inspect.
When you went out there, what did you notice about the steps and that landing area?
Well, at first, I was a bit alarmed because there were some pretty obvious issues.
Page 7, line 9. If there were such obvious safety issues, why didn't you issue any citations?
As I said, I got pretty alarmed, so I asked the manager that was walking around with me during the inspection about the fact that there were no guardrails and about the cracked concrete. The manager told me that there used to be guardrails, but they were removed because Chimes used that landing area as a loading dock.
Why does that matter?
Because loading docks don't have to have guardrails.
Page 8, line 20. Is there any OSHA regulation that does specifically discuss loading docks?
Yes. 1910.28 B13 clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto a dock with a bar in your way.
Page 9, line 1. Have you had a chance to review the deposition of Kelly Danes?
Yes, I have.
Well, what do you have to say about all of the OSHA regulations that Kelly Danes testified were violated by the defendant because of the condition of that landing area in the back of the store?
None of them deal with loading docks, which is what Chimes was using this area as. It wasn't just a stairwell or a landing area at the top of a stairwell. This was a loading dock, and the provisions cited by Kelly Danes don't deal with loading docks.
And was this area behind the store exclusively used as a loading dock?
No. It's my understanding that employees also went out there to throw trash in the dumpster and to take breaks. And it's certainly possible that employees went there and did other things as well. But I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key thing here is that Chimes used this area as a loading dock. That's what matters.
Your Honor, that concludes our reading of this witness's deposition.
2834 remaining. I assume you're going to do some cross of that same deponent, Mr. White.
Yes, Your Honor, and my co-counsel will help me out with that. That's all
Excellent.
right.
30 minutes and 5 seconds. Whenever you start talking, I'll start timing.
All right. We're going to be starting on page 116 of the record and reading from lines 1 through 19. Is Exhibit 37 a true and correct copy of that OSHA report from May 2nd, 2003?
Yes, it is.
Why does this report exist?
This is one of the things that OSHA does on a regular basis: review proposed regulations and discuss the potential benefits or drawback of those proposed regulations. That's exactly what they were doing here in their role as a federal agency.
Why is this relevant to your opinion about that area in the back of Chimes?
Because in this report, OSHA was interpreting some proposed regulations related to guardrails, and OSHA made it clear that if those regulations pass, they would not apply to loading docks. You can see it under section 1910.324I.
Did OSHA ever pass these proposed regulations?
No, but that doesn't matter because I'm just referencing the interpretation from OSHA. That interpretation would be relevant not only to this specific proposed regulation, but to any OSHA regulation involving guardrails.
Your Honor, at this time, we would like to read on to the record statements from Exhibit 37 that this expert witness has authenticated and relied on.
Any objection?
Yes, Your Honor. Under Rule 403, may I be heard?
Sure.
Your Honor, these are regulations as mentioned by this witness's deposition that were not ultimately passed. This goes to misleading the jury because of the fact that this regulation was never actually made into something that OSHA follows. And therefore, for the members of the jury to hear lines from this proposal that never actually came into law will mislead them into believing that it actually governs.
Mr. White, response.
Yes, Your Honor. As you can see, and as we all just heard, this witness admitted that this report was relevant to his investigation. Under Federal Rule of Evidence 702, opinion testimony by experts is allowed when it's based on sufficient facts and reliable principles. So unless opposing counsel is willing to stipulate that their expert witness's testimony isn't based on sufficient facts and reliable principles, and also willing to strike from the record everything else they've read from his deposition, the jury should be able to hear what was in this report that this expert witness relied on?
Rebuttal.
Your Honor, Rule 702 cannot be used as a backdoor to introduce evidence that not only is substantially more prejudicial than probative, but the fact that it doesn't even govern. Just the fact that this expert witness relied on this document doesn't mean that opposing counsel can use Rule 702 to bring it in. Furthermore, Your Honor, the fact that this is not a past regulation, it is not binding, the members of the jury should not hear this evidence.
Okay, so your expert did, I don't need any further argument. Your expert did rely on this in preparing the report, correct?
Your Honor, they mentioned it in the
yes
report.
Or no?
Yes,
They
mentioned it in the report.
And then did we hear what the regulation was already read into the record in front of the jury?
Yes, that there is no
regulation. And you didn't object at that time?
Correct.
So the jury is tracking the regulation, right?
Yes.
Okay, so we're going to let the jury hear what the content of that regulation is. If you don't want the jury to hear it, right, we need to have you object before it's introduced to the jury. But also, I think it's a pretty big stretch to say that something that your expert relied on is inadmissible under 403 when, as Mr. White points out, right, that's probably highly relevant, to understanding the whole of their testimony, right, if they relied on that, right? So I'm gonna overrule that objection, and I'll go ahead and let you proceed, Mr. White. Whenever you start talking again, I'll start timing. You've got 28:30 remaining.
Yes, Your Honor. Mr. Haddon, if you could publish Exhibit 37. And I'm just going to start reading where the highlight starts. And that's under section 4.1 and then also subsection 2 as well. And actually, I'll start reading at the beginning of subsection 1. Employers are not required to install guardrail systems on the working side platforms such as loading docks and teaming tables, where the employer can demonstrate that the presence of guardrails would prevent the performance of work. All of the other sides of the loading dock and teaming table shall be guarded as required by section 1910.27 by a fall protection system meeting the requirements of section 1910.28. And with that, Your Honor, we have nothing else for this witness.
That leaves you with 27:28. Okay, anything further from defense before we move into closing statements?
No, Your Honor, defense is ready for closing arguments.
Okay, why don't we take, let's say, a 5-minute comfort break. Fellow judges, if you leave, I'm going to ask that you turn your camera on. That way we can tell that you're gone. And then when you return, you can turn your camera off. So 5 minutes, we'll be back at 11:18 from that bathroom break. So anybody that leaves, make sure you turn your camera on, okay? All right, looks like we've got Judge Alexander back. I'm guessing all my other judges are back as well, because their cameras are off. And there's Ms. Sahakian and Mr. White. Gonna do one last, all my judges are back, correct? Yes, there's Miss Gabby. Okay, and we saw Mr. Alexander. There's Mr. Doyle. And I'm assuming that we've got our remaining judge, Mr. Bailey, still with us. There he is in outer space. Okay, guys, whenever y'all are ready, Mr. Alexander, there we go. Okay, so plaintiff, you've got 27:28. Let me make sure that your clock's set. It is. Whenever you start talking, I will start timing, and then of course, any time that you have left will be reserved for your rebuttal. If
Yes,
you
Your Honor.
take one.
Convenience first, safety second, responsibility last. The defendant, Chimes Department Store, had a railing removed from around the concrete platform and stairway behind their store. This made for easier access to load merchandise. Convenience. Then they ordered their employees to take their smoke breaks behind their store in the dark on this concrete platform using the stairway with missing railings. Safety second. On January 23rd, 2019, my client, Jordan Gilmore, fell off these stairs while taking a smoke break, lost his balance, and landed on his backside. Instead of having his back, they're the reasons he landed on it. Because in their eyes, in their pocketbook, responsibility comes last. Jordan Gilmore is a simple person with simple needs. Today, he isn't asking for anything extraordinary or even out of the ordinary. You see, he just worked as a cashier at Chimes Department Store. It's not the type of job anyone would consider risky or dangerous. A typical day for a cashier includes scanning barcodes and pressing buttons on a cash register. He never expected that something as simple as taking a break would leave him broken, out of a job, and in court, begging for the defendant to just take responsibility. So today, Jordan Gilmore has brought suit against Chimes Department Store for negligence. Now, negligence is somewhat of a fancy legal term, but at its heart, negligence is really about the relationship that we have as a society with each other and the responsibility that comes with it. The defendant had a responsibility to act in a reasonable and careful manner towards their employees. And their failure to do so led to Jordan Gilmore's fall. We only need to prove this by a preponderance of the evidence. A helpful way to visualize this burden is to consider an arm wrestling contest. For Jordan to win today, he doesn't have to slam Chimes' hand down on the table. He doesn't have to struggle with them until they give up. He doesn't even have to scream or make them scream. He merely needs to move their fist slightly to the left, cause their grip to slip until it moves barely enough to notice. This isn't a burden we shy away from because we've already met it many times over. So let's start by breaking this down into three simple questions. First, did the conditions that led to Jordan Gilmore's fall pose an unreasonable risk of harm? Second, did Chimes Department Store know, or should they have reasonably known, of the danger? And third, did Chimes Department Store fail to exercise ordinary care to protect Jordan Gilmore from unreasonable risk of harm? To determine whether Jordan was subject to unreasonable risk, we simply need to ask ourselves, given everything we know about Jordan and the type of work he did, is the harm he suffered something you'd expect? Let's break this down. Jordan Gilmore wasn't a warehouse worker. He didn't work in a position that required any special safety training, wasn't responsible for loading or unloading delivery trucks. Jordan Gilmore was a cashier. Despite this, Jordan was expected to go up and down concrete stairs with no railing in pitch black conditions where the ash from his cigarette was the only light Chimes felt he was entitled to. The only person willing to tell you that that was reasonable is the one person who has everything to lose. These conditions weren't kind, they weren't careful, and they weren't considerate. They were just convenient. Members of the jury, The next question you'll be asked to answer is whether Chimes department store knew or should have known of the danger. Well, not only did Chimes know about the danger, they were the reason the danger existed. During my cross-examination of Reese Geller, the owner of Chimes department admitted that Chimes asked their landlord to remove the guardrail from around the steps where Jordan fell. So don't let Chimes tell you that they didn't know this danger existed when they're the reason for it. They can't have it both ways. Where I'm from, someone looking at this would say, pick a struggle. Either admit your decision was the result of bad judgment, or that you were only ever interested in making decisions based on convenience. The dangerous conditions that Chimes created for its workers were generally known by everyone. After Jordan Gilmore fell down while attempting to climb barely visible stairs, the first thing the manager on duty, Lane Kim, says is, well, Chimes should have fixed those stairs a long time ago. This is an admission that the environment wasn't just unsafe, it was broken. Chimes knew about it and they didn't care. The final question on this issue of negligence that you'll be asked to answer is whether Chimes failed to exercise ordinary care. Ordinary care simply means that anyone else in the same or similar circumstances would have exercised the same level of care. Jordan Gilmore trusted Chimes to do what they could to keep him safe, not just because it was the right thing to do, but because that's what they said they would do. During my cross-examination of Reese Geller, she told us she instructed her employees to let her know if there were any safety issues because she cares about their safety. But we found out that that just wasn't true. I'm going to ask my co-counsel, Mr. Haddon, to pull up Exhibit 14. We learned about a report that was made 9 years before Jordan Gilmore's fall. The statement on this report was made by an employee named Jason Stiles. Mr. Stiles alerted Chimes to conditions he felt were dangerous. Not only does this show that Chimes had notice of dangerous conditions on their property, it shows failure to exercise ordinary care. This evidence is important because it put the defendant on notice of conditions that made this area unsafe for their workers. Mr. Stiles said that that back area was dark, but for 9 years, Chimes didn't turn on any lights. Mr. Stiles said he slipped on what he believed was loose concrete, but for 9 years, Chimes didn't remove or repave that stairway. Mr. Stiles said that he fell face first because there was nothing to grab onto. For 9 years, Chimes didn't reinstall a guardrail next to the stairs. 9 years of incompetence, 9 years they knew, 9 years of inconvenience. Do you remember when I crossed Miss Geller and she admitted that she told her employees, she instructed them to let her know if there were any safety concerns? Someone let her know. And then she admitted she never reached out to Kermit. She never reached out to her landlord. You know why she never reached out to her landlord? Because she knew it wasn't their responsibility. She knew that they were actually exercising control over this area. During your jury deliberations, you're gonna get the opportunity to review the testimony of our expert witness, Kelly Danes. Now, Kelly Danes is a professional engineer with a degree in mechanical engineering. And she has a background in investigating engineering issues. In her testimony, she talks about the Occupational Safety and Health Administration, also known as OSHA. You see, OSHA sets safety standards just like the ones that were needed in this case. They set safety standards to help us determine a standard of care. What you'll learn is that OSHA's standards apply to the stairs that Jordan was walking up when he fell. OSHA requires that these types of areas be properly lit and that the stairways have guardrails on all exposed sides. This was their standard of care, and they knew it was their standard of care. Chimes breached their standard of care by failing to act on the very safety issues they told their employees to alert them to, and by failing to incorporate standards set by OSHA. Now, today, opposing counsel spent a lot of time shifting the blame. Now, I wrote some incidents of that just happened during trial. During her cross of Mr. Gilmore, opposing counsel asked why he didn't just smoke in his car. She asked why he never complained. She asked about why he jumped. She asked about whether or not he had a cell phone in his hand. As if these were all responsibilities left with Jordan Gilmore. I want you to think about this. Jordan Gilmore told us he needed to put his hand on the wall to keep his balance. And sometimes he needed to have another hand holding the trash. Opposing counsel is arguing that he should have had a third hand holding the cell phone. The amount of care that they place on Jordan Gilmore, an employee, if they just put a portion of that responsibility on Chimes, we wouldn't be here today. The defense provided you with the testimony of their expert, or at least they call him an expert. His name is Perry Hayden. As you're reviewing his statements, it's important for you to note that he admits that a great deal of his opinions are based on proposed standards that never actually passed. These are standards that don't even apply, standards that don't govern. These fake standards are meant to distract you from Chimes' negligence. Opposing counsel is going to stand before you momentarily, and they're going to try to convince you that what happened to Jordan Gilmore is someone else's fault, or maybe even it's no one's fault. After all, according to them, the area where the accident happened isn't under their control. Well, that's a false statement. And that's a false statement that they're going to put a lot of energy into trying to sell you. So I want to talk about it for a moment. When they tell you they couldn't put up a guardrail attached to the massive, when they couldn't put up a guardrail or attach a lamp to their building because the area was outside of their control, that argument is trash. And yes, I'm talking about the massive trash can they placed in that loading area. You see, not only did they not get permission to put a massive trash can in front of the loading area, they never even notified their landlord. So is it Kermit who has control over the loading area? Or is it Chimes? Members of the jury, the answer is Chimes. See, opposing counsel wants to place the burden of managing this area. They want to place the responsibility of managing this area on Kermit, even though their own witness, Ms. Geller, admitted she wasn't in communication with Kermit. She didn't let Kermit know about different issues that were experienced in this area. She didn't let Kermit know that there were safety issues that had occurred years prior. They were exercising control. Momentarily, you're going to be provided with some instructions that explain the issue of control. There are two ways we can prove who had control of this loading area. And one of the ways is through a contractual agreement. And that's what opposing counsel wants to focus on. The other way we can prove control is through the exercise of control. Opposing counsel spent a lot of time talking about a contractual agreement because they didn't want you to focus on the exercise of control. Even if we do accept the rationale that Kermit was contractually in control of the loading area and not Chimes, Kermit doesn't make Chimes employees walk around the dark at night. Kermit doesn't make Chimes employees step on barely visible stairs with no guardrail to take out the trash. Kermit doesn't make the loading area the designated location for smoking breaks. Even if Chimes isn't contractually responsible for these dangerous conditions, they're liable for knowing about them and then sending their employees there anyway. Opposing counsel talked about the why. Well, why did Jordan Gilmore go back there? Why was Jordan Gilmore placed in harm's way? The answer is Chimes. Now, members of the jury, along with those instructions that I showed you, you'll be given a jury charge. And that jury charge is something that you're going to take with you into your deliberations. You're going to be asked to determine if chimes proximately caused Jordan Gilmore's fall. Or in other words, if their actions or failure to act led to the January 23rd incident. Well, based on all of the facts that came out throughout the course of this trial, the answer to that question is a resounding yes. The level of carelessness and control they exercised over the loading area and their employees makes them 100% liable. At some point, we need to say enough is enough. When you hire someone to do a job, when you tell them how to do it, when you tell them where to do it, you don't get to use disingenuous loopholes to avoid liability. Everyone has to answer for their decisions, for their choices, but Chimes doesn't agree. Tell the defendant that they can't choose convenience first. Tell them that they can't place safety second, and tell them they can never put responsibility last. Hold them liable.
$12:09 remaining. And let me get your 28:34 on the clock. All right, defense, whenever you're ready, 28:34 remaining.
Members of the jury, when accidents like this happen, it's only natural to want to find someone to blame. It's natural to want to find someone to hold responsible. But in this courtroom and under this system of justice, it's not just about holding someone responsible. It's about holding the right people responsible. And today you learned that it was Kermit Realty Group who was in charge of making sure that loading dock was safe. And as hard as it might be to say, and as hard as it may be for Mr. Gilmore to hear, it was his decisions that led to a harsh consequence. Now, your job today is to determine whether Chimes will be held responsible for Kermit Realty's and the plaintiff's rash decisions. Now, Judge Gardner will tell you that the plaintiff had a burden to prove by the greater weight of the evidence that Chimes was responsible for this injury. Now, opposing counsel mentioned an arm wrestling match. Now, if you still use that same example, if that arm stays in the middle and it doesn't move an inch, members of the jury, you have to find for the defendant. And today they failed to meet that burden because instead the evidence has shown two things. First, that Chimes wasn't even the one responsible for maintaining that loading dock. And second, that it was the plaintiff's decisions that led to his injury. So let's talk about that first thing the evidence showed, that Chimes wasn't even the one responsible for that loading dock area. And today, Ms. Geller took the stand and she told you about her lease agreement with Kermit Realty. And she told you how they decided that Kermit Realty was going to control the common areas of that lease, which included the loading dock area. You heard that Kermit Realty had taken this responsibility upon themselves in this lease agreement. And you saw that clear in Exhibit 11. And members of the jury, they tried to tell you that just because Chimes put a dumpster in that common area, that means they had control of it. But the words are clear. The common areas, the loading dock areas, they're all controlled by Kermit Realty. Just putting a dumpster there didn't make that power go away. Now, you also heard from someone who actually deals with OSHA regulations, Mr. Perry Hayden. You heard his deposition testimony where he told you that those loading docks, well, they don't need guardrails. And that's because OSHA doesn't want to mess with the process of what a loading dock is used for. These companies have to be able to get merchandise and take it into the store. If there's a railing, think about it, members of the jury. It's just common sense. How would they get their items inside? In fact, you heard Perry Hayden tell you that just because somebody goes outside and eats a sandwich on that loading dock, that doesn't transform the loading dock into a diner. And he's right. And think about it. How can they change the words of an entire lease? That doesn't make any sense. But then they tried to tell you that no, it was their witness that had the right interpretation of the OSHA regulations. But Perry Hayden, remember, in 2018, actually went to Chime's department store. He did an entire investigation, and guess what? He didn't find that Chimes was in violation of any OSHA regulations. In fact, he didn't issue a citation or a warning. Members of the jury, who is better to say that there were no OSHA violations than an OSHA officer himself? But they made a big deal about this prior incident in 2010 that should have put Chimes on notice to make a fix. But guess what? That investigation by the OSHA officer, that happened after that 2010 incident. And when that officer went to the location, he didn't find anything wrong. So members of the jury, think about it. Perry Hayden has no horse in this race. He's not even getting paid today. He's just here to tell you what his investigation found. And the truth is that there were no OSHA violations on that loading dock. And so that brings me to the second thing the evidence has shown, that it was the plaintiff's decisions that led to his injuries. Now, members of the jury, no one denies that what happened to the plaintiff is terrible. It is. But that doesn't mean that you have to ignore his actions in this case. You actually have to consider it, because we've taken on the affirmative defense of comparative negligence. All that means is that you have to consider the plaintiff's actions compared to how a reasonable person would have acted in that situation. So let's go through about the different things that common sense tells you and the different things that a reasonable person would have done in that situation. You first heard that it was cold that night, it was windy, and it was pitch dark. And the plaintiff isn't just any old employee from Chimes. He's been working there for over 10 years. He knows that that light outside, well, that light is going to be off. So he doesn't decide to take a cell phone with him to try to put a flashlight on the stairs to see where he's going. He doesn't try to ask his coworker who's with him to bring her cell phone so they can see where they're going. No. Instead, he just rushes to the bottom of the loading dock. But let's put that aside for a moment. Let's say he gets to the bottom of the loading dock. Everything's fine. When he's coming back up those steps, members of the jury, the plaintiff saw that the door was blocking the steps. You saw that in this photo. He admitted on cross-examination, this is exactly how those steps look. Would a reasonable person really look at these steps and say, you know what? I can make it around that corner, knowing that there's no guardrail on the side, knowing that it leaves him this much space to get around. So what does he do? He rushes up those stairs. He does a maneuver around it to try to get around the door. Doesn't ask his coworker to try to open that door all the way. Doesn't try to ask his coworker to move out of the way. No. But the best part, members of the jury, the best part of it all was that now that the plaintiff came to court and realized that his actions weren't really reasonable, is the reason why at his deposition for the first time ever, we're hearing, oh, guess what? I put my hand on the wall and I was guiding myself so that I could see where I was going. Well, where was that statement when he was talking to Chimes management 2 days after this incident occurred? Why didn't he say anything about guiding himself with his hand then? Well, members of the jury, that's because the plaintiff knows. He has to make his actions sound more reasonable to you. This wasn't about convenience, members of the jury. This was about the law. And at the end of the day, the law didn't require a guardrail on that loading dock. But what the plaintiff did? The plaintiff prioritized carelessness first and caution at the very last. Now, in a moment, Judge Gardner is going to give you this jury charge. And it's going to ask you one question. Did the negligence of any of those named below proximately cause the occurrence or injury in question? Now, because you know Chimes department stores didn't control that area, because you know that Chimes department store didn't cause this accident, we ask you to answer no next to their name. Now, what you did hear today was that Kermit Realty Group was in charge of that loading dock. And because they could have made those changes, because they could have made that area safer, we ask you to answer yes next to their name. And finally, members of the jury, because you heard that the plaintiff's actions, well, none of them were reasonable. He didn't follow common sense. And because of that, we ask you to answer yes next to his name. Now, on the second page of this jury charge, you'll be asked to apportion different percentages of liability to each of these people. Now, we trust you to use your common sense and wisdom to split the amounts between Kermit Realty Group and the plaintiff. Members of the jury, this is a case that prioritizes putting the right people at the center of responsibility. Chimes department stores relied on Kermit Realty Group to uphold their end of the bargain. And as hard as it is to say, they depended on the plaintiff to use his common sense. But unfortunately, hasty decisions lead to harsh consequences. Now, as a juror in this case, we ask you to beware of making hasty decisions and to hold the right people accountable in this trial. Find the defendant not liable.
Give me just 1 second to reset the clock. You had 17:13 left over, just for your edification.
I won't need nearly half of that time.
No. You've got 12:09. I was telling
Okay.
defense just if they, for whatever reason, wanted that data point. Okay, so 12:09 remaining. Whenever you start, I'll start timing.
Opposing counsel spent a lot of time talking about the fact that Chimes had to ask for permission to remove the guardrail, and that shows that they don't have control. That shows they didn't have responsibility. They knew if they got Kermit to take down those guardrails, they could blame anyone else. They could blame Kermit for any safety issues that resulted. Even though they're the ones who had that guardrail removed, they had it removed. That's control. Opposing counsel also spent a lot of time talking about whether or not Mr. Gilmore put his hand on the wall of the loading area. She implied she doesn't believe him. But it doesn't matter because he shouldn't have had to hold on to the wall. If that was her client's expectation, Chimes should have installed a guardrail. When Jordan Gilmore took a job at Chimes department store, he thought he'd be working for the Gellers. You met Miss Geller on the stand. You saw her smile. He thought he'd be working for her family business, treated like family. Ms. Geller testified today that she cares about her employees. She cares about their safety and that she's responsible for them. But her attorneys disagree. So you're left with a very complex challenge. Do you want to believe Ms. Geller when she says she wanted to keep her employees like Mr. Gilmore safe? Or do you believe her attorneys who say it wasn't her responsibility and have now chosen to blame a 10-year Chimes veteran? Believe Ms. Geller when she says she's responsible for her employees' safety. Hold her to her words and find Chimes liable.
Okay, 10:15 remaining, again, just if you want that data point. Okay, so what we're gonna do is we're gonna go turn our ballots in, then we'll come back and we'll do a very brief commentary. We'll do that after the ballots are in, so everybody just hang tight for a minute. Okay, cool. Very good job, guys. All the ballots are in. So we'll go through, give some very brief commentary. I'm gonna be rude and go first. It's my wife's birthday this week, so we're going out. So I'm gonna knock mine out and then I'm gonna leave. I'm sorry. Okay, just good job. I'll try to focus on I guess the negatives because that's more productive. So plaintiff's counsel, I thought the opening was pretty good. It ended kind of abruptly. I thought everybody's non-examination portions sometimes ended a little abruptly. It was hard to tell that they were over. But the main thing I'd say for you, Josh, is that have you ever watched barrel racing with the horses? When they run around the barrels.
Yeah.
They get real excited, and they get what's called gate sour, and they you see them back in the paddocks wanting to go insane. You kind of have some of that with examination, right? So like the plaintiff wasn't, or the examinee wasn't even on the screen, right? You started asking questions. That's just adrenaline, right? But try to, temper that as much as you can. And it's hard to do, because you're excited, just like those horses are. So I can't really blame you. The only other thing I'll say, I thought both the second shares were really, really good. I thought that was some of the most compelling, deposition readings that we heard. The one thing I'll mention, and I'm loath to do this, it didn't affect my decision in any way, but I did just want to say to Mr. Haddock, or Hayden, sorry, Mr. Hayden, make sure that your tie's fixed before you come on the screen, right? It was kind of off to the side and you fixed it when you came back on the screen, but just, that's a Zoom thing that's hard to know. But if you can, look in a mirror real quick or look in your cell phone camera and see, hey, that my tie is looking fine. Didn't affect my decision anyway. Just wanted to mention that. Okay.
Thank you.
Yeah, absolutely. So for defense, I think a lot of the objections were kind of focused on the wrong thing. One thing that you didn't object to that just kind of blew me away was he put, an entire deposition up on the screen. You didn't object, right? I mean, that's not how we refresh a witness, right? We don't just publish a full deposition, right? And then the things you were focused on, right? Especially I thought the character evidence thing kind of beggared belief, right? It's not character evidence. Because we're not really talking about a human actor. I suppose you could make the stretch that it's the character of the company, but it doesn't really fit neatly in there. And so I thought that argument was a little bit of a stretch. I also thought the theme was just a little unfocused. It wasn't clear on who you were going after. You spent a lot of time in the evidentiary portion building up to Kermit kind of being the one that was in control. And you started off with a cursory, which I always think is good, right? We feel sorry for the plaintiff kind of thing, but that was then immediately undercut, right, by your theme of the hasty actions lead to harsh consequences, right? And it seemed like the focus really was on the plaintiff did something wrong. Nonetheless, right, you're putting on all this evidence of Kermit doing something wrong, and I think that's an easier sell, right? I don't think you have to necessarily say it was just Kermit that was responsible, but I don't know why you wouldn't just at least slightly flip-flop those, right, and make the emphasis on Kermit. It's an easier sell, right? They're not even in the case, but it's a win for you. Why not do that instead of taking a punch at the injured person? I don't know. I thought you did a lot of things really good, though. I thought your cross was especially effective, highlighting all the things he could have done differently. Overall, thought it was a really good round. I enjoyed watching it, and I wish you both the best of luck in the future rounds. I'm sure these folks have some great information for you as well. Thank you.
Thank you.
Thank you so much.
As what appears to be the oldest guy in the room, I'll go next. First of all, I will say this with all candor. I would second chair either one of you guys. I thought it was amazing. I feel good about the future of this business. Some days I don't, because they're trying to take the jury trial away from us. But with folks like you at the helm, I feel really, really good about it. I too will focus just on a few things. One of the things you guys have to remember is, especially in this tournament, we're not provided the packet, so we know nothing about the case. You all were talking a lot about that landing and about the door and how it blocks things. I don't know if you have ever studied how they make movies, but I was a movie maker for a very long time. And what they do is, if you're going to focus in on a storefront in New York City, right, you start with called an establishing shot. You show that we're in New York City, and then you move in to the storefront, right? So we can put it all into perspective. You all were showing me what you all were calling a door. It didn't look like a door to me. I don't know what it was that I was looking at that entire time. So if there's an establishing shot that you have to show the door, where it is, where it's located on that wall, start with that, and then move your way in to show me why that door was safe or was not safe, depending on what side you're on. Josh, I thought you did an amazing job at making me angry, but I'm still not sure what I'm angry about, okay? If there are defects, and look, I'm a plaintiff's attorney and I have to prove premises liability cases, and I will tell you those are the hardest to prove, okay? But I thought you did a great job. But from day one, or from moment one, list for me those defects. Tell me what they are. I still don't know what you were saying. Was it the lighting? Was it the guardrail? Was it the chips in the stairs? I don't know. Maybe it's all of them. And frankly, I'd put them all up there to get the jury angry, because you're going to need to get the jury angry in this case. So, and then harp on that. And then at the end, in closing argument, put checks. Did we prove that? Yes. Did we prove that? Yes. Did we prove that? Yes. So we can at least know what I'm supposed to be looking for throughout the trial as to what made those premises unsafe. Rima, you put all your eggs in a very dangerous basket, okay, by saying it was the realty company's fault. You said on opening statement, the landing was not safe. Okay, that's a dangerous position. I think as a defense lawyer in this case, you need to take the position, it's a very safe landing. It's doing exactly what it was designed to do, right? And because you're the one who asked the realty company to take the guardrail off, okay? And that if people are just safe, if they take the precautions that anybody would know to take under those circumstances, nothing bad would happen. But to call it unsafe in your opening statement, Josh, you should have been all over that, my friend. I'd have written that down and I would have said it every time I examined the witness. Now, did you hear your lawyer say on opening statement that that landing was unsafe? Did you hear him say that? And are you telling this jury, you know it's unsafe, and yet you took no precautions? So that, anyway, and then lastly, when you have writings that you, and this goes to both of y'all, that you want me to read as a juror, leave them up for me to read them. You were flashing them and taking them down, flashing them and taking them down. I want to read it in context. I don't just want to read what you highlighted. When you do that, that makes me curious as a juror. Why are they only highlighting that and then taking it down? I want to read the whole thing. So give me, you want to empower the jury to be a CSI investigator. It's what I always tell young lawyers. Empower the jury to be a CSI investigator and to make their own decision. You don't get to make their decision. You empower me to make my own. You just make it easy for me to make the decision on your side or the other. I'm going to stop. When the tournament's over, give me a call. The three of us will start a firm, and I don't know what it'll be called yet. You guys can argue about that, but I loved all of your presentations. I thought you were amazing.
Yes, I just came back to let everybody know when the critiques are done. I think this is clear, but you're free to go. And as you finish your critiques, if you want to leave, you're also free to do so. So good luck, guys, in the future rounds.
I'm happy to go next, Gabby, unless
that's fine. Megan Servage said your son has a ball game, so go get it done.
Yeah, no. So yeah, I'll echo. It was a really good round to watch. I'll pick up on a couple of things Joe said, and this first one may be my ignorance of what you're allowed to do under the competition. But on exhibits, I don't know if there is a way. It looked like y'all were showing them on Adobe. But if you're talking about a provision, talking about a clause, blow it up or zoom it in or something that just draws our attention to it. And similarly, the other thought I had on what Joe mentioned, if there is not a picture of a door in that context, if you're allowed to in the competition, draw it out, make a demonstrative there on the spot. And that, that engages us and helps us know, it helps us with what Joe said. Josh, I thought your theme was great. I thought it was really, really good. It felt throughout the whole, it streamlined the whole process. Jumping off of what the judge said, the way I'd put it is, I think you've got to have a little bit of righteous indignation as a plaintiff's lawyer, but you were kind of at volume 10 the whole time. And I think it's more persuasive to kind of build up and make your point at the right points rather than being at a volume 10 or not a volume 10, but an energy level 10 the whole time. And yeah, and then the objection that I thought, okay, if it were a jury, for an actual jury trial, I'm sure y'all would have approached the bench, but the one about the question being vague, if I'm a juror, and I think it was the question, is it safe? Or you were objecting to the phrase safe as being vague. And as a juror, I would take that as, do you defendant not know what safe means? So that was a little, and I thought, Josh, you did well to respond to that one. So be careful with your objections, make them worthwhile. Don't make them ones that can be pushed back pretty quickly. So those those are the ones I have, but really good job and wish you the best of luck.
I will go real quick here, not to waste y'all's time. I thought y'all both did an excellent job. You're very good advocates. Your co-counsels were very quick and efficient, and I appreciate that. Plaintiff's opening statement, Mr. White, I really liked how you used an exhibit in your opening statement. I think it goes towards what Joe's saying, though we needed to be oriented a little more, but I did appreciate seeing the area which you're asking your jurors to kind of make a deliberation on. With respect to defendant's opening statement, I like your demeanor. I think you're a reasonable person. I think we have to remember I'm civil defense, that and I'm not trying to be, it sounds a little trite when you're saying hasty decisions lead to harsh consequences, because it's not really a decision, right? At the end of the day, this is an accident, someone fell. And so it's orienting them on that theme. He didn't really decide, and he did decide to sue, but he didn't really decide to fall off for what we know. So I think it's just making sure you got to ride one horse, and I think they've already hit on it, all the other judges. And I think I would have ridden the horse of Kermit, just because it's a lot easier to have that empty chair defendant take all the blame. So that's just kind of more on stylistic what I would have done. But I think you were poised. I think you were the reasonable person. I appreciated that. Going to direct examination, I think that defendant's direct examination was very fluid. I appreciated how quickly it moved. For plaintiff on cross-examination of the store owner, I appreciated how you didn't let her non-responsiveness at sometimes get in your way. And so sometimes, you can push back. I know y'all have witnesses on this, but she kept on trying to kind of squirrel out of that. And she would be like, well, but I didn't have, that was their control. That was their job. We didn't have control. So you ignored it, and I appreciated it. But I think sometimes you got to push back, but I get that we only have the witnesses here that we have. With respect to evidence, objections and responses, for defense, Ms. Sahakian, I appreciated that when the judge basically overruled you, you were respectful and you kept with it. If a judge asks you immediately a factual question, and I think Judge Gardner but it's a yes or no. So I understand that you have to take the position. Well, I don't remember what the question was specifically, but just be sure to be on your toes, yes or no, because it's got to move quick. And we're not really trying to advocate because the judge is asking a factual question. And then finally, on closing statement, I laughed out loud. I'm glad my camera was off when he said that opinion is garbage. I thought that was a very funny statement. And I think that I really enjoyed how down to earth that was. I think that's something that maybe both of you, just in next rounds, wherever you go work on, is when you're talking to your jurors. And I know it's y'all prepared in mock trial for this, but be a little more yourselves. And I know that it's rehearsed and poised, and I appreciate it, but I think sometimes you gotta be a little more yourselves and a little more down to earth, because your jurors want to know who you are as the advocate. But overall, I thought y'all did excellent, and I really appreciate the time to look in on this mock trial.
Okay, can y'all hear me? Cool. I'm a plaintiff's lawyer, and I actually just got out of trial a couple weeks ago. So I appreciate the stuff that y'all are going through, because I spent 2 or 3 years on my case, and y'all had 24 hours. So that's tough. Let me give you a couple things that I think, first of all, you both did great, but let me give you a couple things that I think will help you moving forward. Josh, the biggest weakness of your case, and like I said, I haven't seen the packet, and this is the first one I've seen competition-wise. The biggest weakness in your case is the document that shows that the defendant is not responsible for that area. When you were cross-examining or in direct examination, I think again on cross-examination, you were asking questions of the building owner about who was responsible based upon a contract. That is a legal interpretation which requires expert evidence. If your opposing counsel asks their witness to interpret a contract, you got to jump on them and object immediately. You cannot let her dictate what the responsibilities are. The document speaks for itself. Don't let her say, we're not responsible under this agreement. She doesn't know. She's not an expert, right? The other thing I wanted to talk to you about, so when I tried my case a couple of weeks ago, I hired a jury consultant. What the jury consultant reminded me of is something we learned in law school, but we don't think about very much. Jurors don't care about your client. And I thought, you know, the way as a plaintiff's lawyer that we make money is to present our case in such a way that the jurors hate the defendant. I think you're spending too much time in your opening talking about your client. For example, you talk about he fell and he hurt his backside. Okay. That to me makes me go as a juror, why do I care about this case, right? Obviously, your guy can't work anymore and you need to focus on that. But I would talk about my client as little as possible in opening. I'd introduce him. I'd say, that's my client at counsel table. And I'd spend the rest of the time focusing on how bad the defendant is. Because where a jury is going to agree with you is the risk and danger to society. Anybody who's on this back step could get injured. They don't care about your client in particular, right? So that's what I would focus on. Defendant, you did a great job with regard to being poised in a position that I think is kind of hard. Being a defense attorney in general is just kind of hard because you're effectively saying, yeah, this person got hurt, but we don't care. But I think one thing that will help you, and I appreciate Joe's comments because I had the same thing. One thing that I think will actually help you as you move forward is if you spend time in your opening statement listing all of the other things that contributed to the danger that you didn't have any involvement with, right? So there's, you know, at least 10 things in this case that you didn't have any control over. He didn't have a cell phone in his hand. You weren't responsible for maintaining this area. He chose to go have a smoke break in the back instead of in the front. If you list those items, what you're doing is you're giving the jury an opportunity to find something else to blame this on other than your client. The other thing that I would tell you is your entire case is based upon OSHA, right? So I would lead off with that and I would tell the jury, you don't have to do anything in this case. You're not an OSHA expert. We have an OSHA expert. Their job is to evaluate risks to society in these particular issues. And they've already done that. And they've already said that we didn't do anything wrong. So you don't even have to make that decision. If you do that, you take it out of the jury's hands and it's the path of least resistance, right? It's just easier for them to say, yeah, we agree with that. Does that make sense? Cool.
Benjamin, let me interrupt real quick though. In real life, ultimate findings of OSHA don't even come into evidence.
True.
I don't know if that's part of your packet, but in real life, their findings don't come in. Now, factual findings do, but the ultimate conclusions don't come into evidence. So it's something as a plaintiff you might want to object to because they don't come into evidence. So that was great. If you guys have any questions of us, great. Otherwise, I practice with my son. So I'm used to being around young lawyers, but I will tell you, I'm really, as weird as this sounds, I'm really proud of both of you guys. You did an amazing job. You really did.
Thank you so much. Thank you all for taking your time to judge this round and volunteering. And thank you so much, Rima. You were absolutely incredible. This was really fun.
Good luck, Josh. Thank you, everyone.
Good luck to both y'all.
Good afternoon, everyone.
Good afternoon.
Good afternoon.
I am sending my cell phone via chat. I see the Honorable Michael Smith is with us. Good to see you, Mr. Smith.
Good to see you, sir. How are you doing?
I'm great. How are things? Did I just see that you just joined a different firm?
I did. More importantly, we just got a jury verdict in Plano yesterday evening, so that's more important.
Good. I start one June the 21st here.
Y'all actually back in courthouses, or are they forcing you to Zoom?
Federal court, we are live. Our federal court in Waco, in essence, never, I mean, we do Zoom hearings, but we've been doing jury trials since October.
I've had 3 live jury trials in the last 2 months. They're wearing us out.
I had one in April, got one in 2 weeks. So, yeah,
Hunter, your facial hair caught me off there. I just realized who I was looking at.
Hey, how are y'all doing?
Good. Been a while.
Yeah, it started out as a COVID experience, but no, it's ended up longer than we all thought, I guess.
Okay.
Good to see y'all.
Do we have everybody here?
Your Honor, on behalf of the plaintiff, everyone's here.
Defense?
On behalf of defense, everyone's also here, Your Honor.
Great. Let's make sure of a couple things. Once we get started, judges will mute their videos, hopefully. So we'll have everybody other than the participants. And I will be the timekeeper. All right. It's not exactly 3 o'clock, but if you guys want to get started, we can get started with your 5-minute pretrial.
Your Honor, if everybody's present and ready to go, including the witnesses, we are ready.
Witnesses? Do I have? Okay, so all of our witnesses are here?
Perfect.
Perfect. All right. Well, then let's start first off with announcements, and then we'll take, if there's housekeeping stuff that anybody wants to do, we'll do that first, and then we'll take any substantive pretrial. Fair enough?
Yes, Your Honor.
All right, we'll start with the plaintiff announcement, and give me any housekeeping you want.
Good afternoon, Your Honor. My name is Rima Sahakian. I'm appearing with my co-counsel, Mr. Darshan Patel, and we represent the plaintiff, Ms. Jordan Gilmore. Your Honor, starting with housekeeping matters, opposing counsel and I were able to meet and confer prior to trial, and we have stipulated to the admissibility of certain exhibits, and we would like to ask Your Honor to pre-admit these exhibits before trial.
Which exhibits do we have agreement on as admissibility?
Your Honor, Exhibit 2, which is a photograph of the landing dock behind the store.
Okay.
Exhibit 4, which is another photograph. Okay. Exhibit 11, which is the lease agreement that the defendant signed.
Okay.
Exhibit 12 is a chart from that same lease agreement.
Okay.
Exhibit 13, which is an email.
Okay.
As well as Exhibit 17, another photograph of the stairs behind the store.
Okay, so I've got exhibits 2, 4, 11, 12, 13, and 17. Is that correct?
Yes, Your
Is there
Honor.
agreement, defense that those can be pre-admitted?
Yes, Your Honor.
All right, then those are admitted. 2, 4, 11, 12, 13, and 17 are admitted and therefore can be used during opening.
Yes, Your Honor. Additionally, the other exhibits in this trial may come in out of order when they're introduced. However, they are pre-marked. We ask that they retain those pre-marked numbers so that they can be referred to based on the numbering in the record.
The exhibits will bear their original number throughout. So whatever it is, it doesn't matter to me what order you introduce them in. We'll take them as they come.
Yes, Your Honor. Additionally, during the course of the trial, opposing counsel and I may ask to approach for a sidebar regarding objections or other matters. We just ask that this is done constructively.
It's constructive, yes, certainly.
With that, Your Honor, the plaintiff has no other housekeeping matters.
Okay, defense, if you will make announcements and then tell me if you've got a preliminary matters that are not substantive.
Yes, Your Honor. Good afternoon. My name is Paulina Pisetsky, and I, along with my co-counsel here, Miss Natalie Bayer.
Good afternoon, Your Honor.
Good afternoon.
We represent the defendant in today's matter, Chimes Department Store, who is represented today by Mr. Reese Geller.
Mr. Geller is the corporate rep?
Yes.
Okay, that'll be good.
We do have some housekeeping matters, Your Honor. First, if we do try to admit any evidence that has not been pre-admitted, are we allowed to share our screen constructively outside the presence of the jury so that everyone in the court, including opposing counsel, we all know what document we're talking about?
Yes, we will share. Obviously, the jury is also judging you, so the jury constructively will not be seeing it, but practically needs to see it so they know what's going on.
Absolutely. And then should we formally ask to tender witnesses as experts, or would you like us to proceed with foundation and ask the opinion questions of these experts?
I'm going to leave that up to you. You can do it however you prefer to do it.
Yes, Your Honor. And then as Your Honor knows, this is a negligence action, and the court provided the court with 4 sets of jury instructions that differed based on our intended theory of the case. And after consulting with our client, we have decided that jury charge number 1 would be the appropriate charge for the jury to hear. And we've shared that with the plaintiff before we started today.
Okay, so we will operate off of jury charge number 1.
Yes, Your Honor. And with that, we're ready to proceed to substantive motions.
Okay, let's do this. Bear with me 1 minute. And for those that are on Zoom, when you see a judge looking at his phone, since we are timing, usually it has to do with that. I know there have been interesting comments from some of the outside participants, but let's do this. Let's start. Plaintiff, you may start.
Your Honor, the plaintiff does not have any substantive motions to take up with the court.
That's easy. All right, we'll go to the defense.
Yes, Your Honor, we have one motion before the court. The defense moves to exclude evidence of a safety measure our client, Chimes Department Store, took after the plaintiff's accident in this case to improve subsequent remedial measure evidence under Rule 407. So by way of background, this is a negligence action in which the plaintiff has alleged that it was the fault of Chimes Department Store when she fell from the stairs that were connected to a loading dock behind that store during her shift one evening. Now, one issue in this case is whether there was adequate lighting out on that dock. Now, there was a light above the loading dock at the time of the fall. However, Chimes Department Store did not have a light switch to turn it on. Now, after the plaintiff's accident, Chimes installed a light switch so that its employees could turn that light on. Should the plaintiff attempt to offer this evidence, it would solely be relevant for the purpose of the plaintiff trying to prove negligence or culpable conduct on the part of the Chimes store. And that's expressly forbidden by Rule 407. So we'd ask to exclude any reference to those actions throughout trial today.
Counsel for the plaintiff, response.
Your Honor, 2 of the exceptions under Rule 407 for a subsequent remedial measure are control and feasibility. First, with regard to control, it is a central issue in this case, as Your Honor is aware, pursuant to the jury charge that the defendant chose to pursue. If Your Honor turns to the third page of that jury charge, it actually discusses how control is going to be either given to the defendant or Kermit Realty, and the jury has to decide that issue. Therefore, we will be using this evidence to show control as well as feasibility, that the defendant could have installed this light at the time. It was feasible for them to do so, and they had control over it to do so, but they failed to do so.
Response, counsel?
Yes, Your Honor. Control of this loading dock itself, yes, it's an issue in this case, but control of that light switch is not an issue. It's undisputed that Chimes did not have access to the light switch at the time of the plaintiff accident. Therefore, any attempt to assert that this evidence would be used only for control or to show feasibility is an attempt to backdoor in otherwise inadmissible subsequent remedial measures evidence that would defeat the purpose of this rule, to allow companies to make its premise safer for its employees without being subjected to the introduction of adverse evidence at trial.
Any last response?
Yes, Your Honor, this was a light switch that controlled the light right above the loading dock. This was actually the area that is at issue in this trial, and therefore the members of the jury should hear that after the fact, because the defendant had control over this area, they were able to make the necessary changes. But at the time the plaintiff was injured, they failed to do so.
Here's what I'm going to do on that. I'm going to carry that forward. I'm going to ask, when we get to that point, ask to approach and tell me that that's what you intend to do. I will have then heard the evidence by that point in time, and I'll be able to make a decision. Without all the other facts, I don't know that it's a clear decision to make one way or the other. So I'm going to carry it forward, quasi granted, but that doesn't mean anything other than let me know, and I'll have heard enough evidence by that point to be able to make a quick ruling. Fair enough?
Yes, Your Honor. With that, defense has no more motions, and we're ready to proceed to openings.
Okay, counsel for plaintiff, you ready to proceed to your opening?
Yes, Your Honor.
All right, you may proceed whenever you're ready.
With risks comes responsibility. Members of the jury, the defendant was more than willing to risk the safety of their employees. But when those risks led to an injury, a serious injury of one of their employees, Jordan Gilmore, the defendant turns around and refuses to take responsibility for those risks. In fact, they've come here to court today and tried to blame anyone and everyone involved, including the person that they put at risk. Now, the issue for you to decide today is whether the defendant will finally be held responsible for the risks they took and the terrible injury that resulted to Jordan Gilmore. But before we talk more about this case, I'd like to introduce you to Jordan Gilmore. Miss Gilmore, will you please turn on your camera? Members of the jury, this is Jordan Gilmore. She's a lifetime resident of Waco, and she was a devoted employee at Chimes department stores for over 10 years. When she takes the stand today, she'll tell you how on January 23rd, 2019, she went out the back of Chimes department stores for a smoke break with her coworker. And she'll tell you that that's where her boss ordered the employees to take their breaks. She'll explain that once she was climbing those stairs back to go in, the dangerous condition that the defendant created caused her to slip, falling on the ground and injuring her leg, requiring her to get over 28 staples. An injury that the defendant could have predicted and should have prevented. Thank you, Ms. Gilmore. Now, as the judge will tell you, we have the burden of proving that it's just more likely than not that the defendant was negligent and that it was their negligence that caused Miss Gilmore's injuries. And today we'll meet that burden because the evidence will show three things. First, the defendant knew that their loading dock was dangerous. Second, the defendant did nothing to fix that dangerous condition. And third, it was the defendant's negligence that led to Miss Gilmore's injuries. So let's first talk about that first thing the evidence will show, that the defendant knew that their loading dock was dangerous. Members of the jury, today you'll hear the deposition testimony of Kelly Danes. He's a mechanical engineer who specializes in safety regulations. You'll hear Mr. Danes tell you that there are certain regulations by OSHA, as well as the International Building Code, that require employers to make the area safe. You'll learn that the regulations require employers to install guardrails, to have adequate lighting outside by their loading docks. And Mr. Danes will give you a laundry list of issues with the loading dock outside of Chimes department store. You'll hear that the steps were cracked and jagged. You'll hear that there was no railing by those steps or on that loading dock. You'll hear that there was no adequate lighting and that the defendant required their employees to go out there to take breaks in darkness. Members of the jury, you'll also hear that the defendant knew about these issues because there was a prior incident with a different employee who fell in that very same location. In fact, it actually included the employee falling in the same conditions. It was in January of 2010. It was dark outside, and the employee couldn't see where they were walking. Members of the jury, that brings me to my second point. The fact that the defendant did nothing to fix that dangerous condition. Today, you're going to see an email in which the defendant emails their landlord, Kermit Realty Group, and asks them to actually remove the railing that was on those stairs you just saw a moment ago. But you'll hear that the tenant before them actually kept those railings there. They didn't remove them. The one that removed them was the defendant. But the emails that you won't see are the ones where the defendant asks their landlord to create safer conditions for their employees. Now, members of the jury, they're going to come up here and they're going to try to argue that the defendant wasn't in control of this area, that the whole responsibility lands on Kermit Realty Group as the landlord. When you're listening to what they tell you, pay attention, because you'll hear that this defendant used that landing dock for more than just a landing dock. They used it as an area where employees regularly took breaks. They used it as an area where employees would go to throw away trash. Pay attention to that, members of the jury, because you'll see that the defendant was in actual control of that loading dock. And so that brings me to the third thing the evidence will show, that it was the defendant's negligence that led to Miss Gilmore's injuries. But to understand that, we have to go back to the day of the accident. It's January 23rd, 2019, and Miss Gilmore is taking a break from work. It's 7 p.m. and she walks outside and it's pitch dark. You'll hear that when she goes outside to take that smoke break, she goes to the bottom of the loading dock. And that's the area that her boss told her to go and take their breaks. They weren't allowed to smoke anywhere else. You'll hear that once Miss Gilmore tried to go up those steps to go back to work, she slipped on the dangerous condition that the defendant created and fell, receiving injuries that changed her life forever. Members of the jury, the defendant put risks overtaking responsibility for the safety of their employees. That's why, at the end of this trial, I'll come before you and I'll ask you to find the only verdict consistent with the evidence, demanded by law, and demanded by justice. A verdict finding the defendant and only the defendant liable. Thank you.
Counsel for defense?
Your Honor, I switched my camera. Can you still see and hear me okay?
I can see and hear you fine. Thank you.
Perfect. May it please the court.
Hang on one second. If one of my scoring judges, if they would also let me know and make sure they can hear us or hear you, that would be great.
Good on my end.
Yes, Your Honor.
All right. You may proceed, counsel.
May it please the court. 2 moments that made all the difference. One in 2005, one in 2019. 2 moments that could have prevented this accident from ever happening. 2 moments that the plaintiff didn't really tell you the full story about. So let me do that for you now. Let me spend a couple of minutes with you talking about the actual evidence you'll hear today. Because what will become crystal clear is that this case isn't about risks that Chime's department store took. It's about 2 moments that made all the difference. So let's start with that moment in 2005. If you can, take a second and think back. Think all the way back to 16 years ago. That's an important time for this case because that's when Chime's department store, my client, signs a brand new lease to open up a store right here in our town, right down on Bosque Avenue in a shopping center. Now, Reese Geller is the owner of Chime's department store. Mr. Geller, could you turn your camera on for us for a second, please? Now, Reese has 3 little kids with his wife, Peyton, and they all live here in Wake. To make ends meet, Mr. Geller runs his family business, Chimes. It's a little store that sells clothes, tools, just about anything you might need. Thanks, Mr. Geller. You can turn your camera off again. Now, in 2005, to be able to open up their family store, Mr. Geller's dad has to sign a lease with the landlord. The landlord called Kermit Realty Group. Now, that landlord owns the lot where the shopping center is. And you're going to get to see that lease today. It's important because in that lease, there's a map that shows exactly what parts of the lot that Chimes, the family store, gets to control, and exactly what parts of the lot the landlord, Kermit Realty Group, still controls. And you'll see that one of the places the landlord kept control of was the exact spot where 14 years later, the plaintiff, Miss Gilmore, got hurt. We're going to talk a lot about that exact spot today. That spot is a loading dock in the back of Chime's store. It's where Mr. Geller, he can unload the things that he sells in his store. But you'll learn that when Mr. Geller's dad first opened up their family store in 2005, it was the landlord that kept control of that loading dock. So when Mr. Geller's dad saw that the loading dock had guardrails around it, he didn't rip them out himself because he wasn't allowed to. He told the landlord about it. Now, you'll learn that Mr. Geller's dad, he sends an email to the landlord about that loading dock. And you'll get to see that email later today. You'll see that he asks the landlord, Hey, can you remove these rails from this loading dock so that we can use it? And then comes the first moment that made all the difference. All the difference for the plaintiff's accident 14 years later. Because in response to that email, the landlord says yes, it will remove the guardrails. And that's exactly what the landlord does. It takes responsibility for that spot. It takes control. The landlord rips those guardrails out and leaves that loading dock looking cracked, crumbling, and dangerous. Leaves that loading dock looking like this. And when the landlord, in that moment in 2005, when he took out those guardrails, the evidence will show he took responsibility for that loading dock, for keeping that loading dock fixed, safe, and secure. Now that moment mattered. But the evidence will show that the landlord failed to do its job. That all those years later, when the plaintiff stepped onto that loading dock, the landlord's failure caused the plaintiff to pay the price. So as that concrete crumbled for 14 years, as the landlord failed year after year to take responsibility for what it had to do, well, Mr. Geller will tell you that he worked hard to keep his business afloat. He was able to hire people to work at his store, including the plaintiff, Ms. Gilmore. And you'll learn that right after the plaintiff started working at Chimes, she started taking breaks out on that loading dock. The evidence will show that the plaintiff knew the loading dock was dark at night, knew the concrete was crumbling, knew there was a door that could sometimes get in the way of going up and down the steps there. And on the night of the accident, you're going to see that the plaintiff did what she did so often. She went out on that loading dock for a smoke, walked down the stairs, took her break, and then tried to come back up. But then she made a choice. And that's that second moment that matters. The second moment that made all the difference. You're going to learn that the plaintiff made a choice to let her friend block her path inside. You're going to learn that the plaintiff's friend, well, she was holding the door open so that it blocked almost the entire step the plaintiff had to use. And the plaintiff chose to take a risk and try to sneak around the edge of it with just inches of space for her to step. And when she made that choice, in that moment, she fell. When she made that choice in that moment, she got hurt. Ladies and gentlemen, there are two moments that made all the difference. Two moments that caused the plaintiff's injuries. The first was a failure by the landlord. The second was a risk by the plaintiff. Now, the evidence today will be clear. Mr. Geller's store, Chimes, it can't be responsible for this accident because those two moments that made all the difference had nothing to do with Chimes and everything to do with the landlord of the property and the plaintiff herself. So at the end of trial, I'll get to talk with you one more time. And it's then that I'll ask you to find Chimes not liable. Thank you for your time.
All right, plaintiff, you may call your first witness.
Plaintiff calls Ms. Jordan Gilmore.
Ms. Gilmore, you have been previously sworn. You may proceed.
Good afternoon. Please introduce yourself to the jury and tell us where you're from.
Good afternoon. My name is Jordan Gilmore. I'm 48 years old and I am from Waco. I've lived here for pretty much my entire life.
What do you do for a living, Miss Gilmore?
Well, I'm currently unemployed. I used to work for Chimes.
What's Chimes?
Chimes is it's a little department store. You can think about it as kind of like a Dillard's or a Macy's, and we sell a little bit of everything. It's just kind of like a little it's like a little discount Dillard's or Macy's.
And how long did you work for Chimes department store?
I worked there for, let's see, for close to 10 years, I would say.
Why'd you leave?
Well, unfortunately, I had an accident, and it took me so long to recover from that accident that by the time that I was ready to go back to work, they apparently filled that position, and they pretty much said, sorry, we don't have a spot for you here anymore.
Miss Gilmore, let's talk more about that accident. Do you remember the events of January 23rd, 2019?
Oh, absolutely. I'm never going to forget that day.
Why do you remember that day?
Because that was the day of the accident when I was hurt.
Let's start from the beginning. What were you doing early afternoon that day?
So early that day, I began my shift at Chimes. My shift begins at, it began from noon and ended around 8 p.m. It was closing. I had the closing shift.
Was your shift an 8-hour shift the day of your accident as well?
Yes.
And what time were you injured?
I was about 7 p.m.
What were you doing when you got injured?
So I was actually coming back from my smoke break.
I want to walk through exactly how you got injured, okay? Where'd you go for your smoke break?
So, Chimes, they had this policy, and it was like these instructions that they sent out, and they said, okay, well, you have to go out back, and that's where we were told to take our smoke break. I think it was because one day Reese came by the store and he saw someone smoking.
Objection, speculation.
Sustained.
Permission to strike any testimony, Your Honor?
Permission to strike. What testimony are you seeking?
Specifically that I think Reese, the end of the sentence.
The jury will be instructed to disregard the last 6 words after I think. You may proceed.
Miss Gilmore, you were telling us about why you went out there to smoke. What type of notice did your boss send you to require you to go out there?
We got a little memo from the store telling us, we weren't allowed, telling us that we were supposed to take our smoke breaks out and behind the store, like near the loading dock, next to the dumpsters, that area.
So besides a smoke break, are there any other times that you actually went out to the loading dock area?
Yeah, I would take out the trash, like once or twice a day.
Your Honor, I have Exhibit 2, which has already been entered into evidence. It's a photograph of the loading dock. Mr. Patel, will you please post Exhibit 2 for the jury? Thank you. Ms. Gilmore, are you able to see that okay?
Yes, I am.
Now, what are we looking at here exactly?
So you are looking at the loading dock. This is the back area of the store.
Ms. Gilmore, where do those doors in the middle there lead to?
So the doors there, they lead to the inside of the store. And so, those 2 double doors go back into the store.
Are those the doors that you use to come from the store outside to the loading dock?
Yes.
And where's the loading dock in this picture?
So right where you see it's right where the doors are, and then you're coming back outside, and it's like that area right in front.
Is that the platform above the stairs?
Yes.
Now, are those the doors you used to get to the loading dock during your break?
Yes.
You said it was about 7 o'clock when you were injured. Well, was it still light outside?
Oh no, it's January, it's winter, and it's by the time 5:30 or 6 hits, it's pitch black.
Well, are there any lights out by the loading dock?
Well, do you see where like that little red circle is? And so, there's a light there, but it's almost never on. Like we don't like the store, we can't turn it on. And like we've told our management, we've told them like countless times, and they haven't done anything about the light.
So why couldn't you turn on the light when you were going outside?
It's some weird, like it's this weird thing. Apparently the light switch is in, I think it's the store next door, next to like the Tractor Supply store. It's not in our store. It's not in the Chimes store. It's in the Tractor Supply store, which isn't even in, it's not a part of Chimes.
Well, did you ever tell Chimes management that you couldn't turn on the light?
Yes, many times.
What did they say?
They pretty much acted like it's not our problem. It's not something that they couldn't do. It wasn't anything they could do about.
Thank you, Mr. Patel. Will you please take down Exhibit 2? Now, was there anyone else with you during your break?
Yes, my coworker, Riley Huntsberger.
What's the first thing you and Riley did when you went outside to the loading area?
So whenever we went outside, Riley would, she stayed up in the loading area, and she like held the door open while I went down the steps to the landing area. And I did that because I wanted to keep the smoke from going back inside the store. And while I was going down the steps, like I would put my right hand on the wall, and that's what I would hold on to make my way down.
Well, let me stop you right there. We'll get to you going down the stairs in a moment, but did Riley join you at the bottom of the dock?
No, she stayed up where the door was.
So when you were walking down the stairs, could you actually see the steps where you were walking?
I mean, the only light we had was the light that was coming outside from the open door. So it was really dark, and it was hard to see.
Your Honor, I have Exhibit 17, which has already been entered into evidence. Mr. Patel, will you please post Exhibit 17? Ms. Gilmore, are these those steps that you were mentioning?
Yes.
As you walked down these steps, was there anything for you to hold on to?
No, nothing at all.
Well, how long were you down there for?
I mean, not long. I mean, 5 or 6 minutes at most. And, being January that night it was cold and windy, and, I wanted to get done as soon as I could.
So what did you do after you got over your smoking break?
So, at that point, I started climbing back up the stairs, and, Riley was holding the door open. Like I said, it was windy that night. And so so I was climbing up the steps, and the door was like right in front of me. And then, I get to that top step, and then all of a sudden my foot slipped and I'm falling.
Ms. Gilmore, let's break that down a little bit more. You mentioned you were going up. Was there a door in your pathway?
Yes.
Did you try to step around the door?
I did.
Why'd you do that?
Well, I mean, there was no other way for me, for me to get through because Riley was holding the door open. And
Your Honor, I have a photograph which has already been pre-admitted as Exhibit 4. And Mr. Patel, will you please post Exhibit 4 for the jury? Thank you. Now, Ms. Gilmore, is this the door leading to the loading dock?
Yes.
Where were you in relation to this door as you were walking up the dock?
So I was a bit off so I was coming back upstairs and then, just, I don't know if you can see like that little, when I was trying to make my way over, I placed my right foot where that step was. I don't know if you can see like that little white little thing in the picture.
So what happened as you stepped around the door?
So as I stepped around the door, my foot slipped and, I fell and I tried to land on both of my feet, but the ground where I fell, it was mostly uneven and I landed on my right leg and then, and then I landed and then I fell backwards onto my bottom.
Ms. Gilmore, were you able to walk afterwards?
Yes, but at that point, my right leg and hip hurt, but I was able to walk.
Thank you, Mr. Patel. Will you please take down Exhibit 4? Now, did you sustain any injuries because of this accident?
Yes, I did.
Did you end up needing surgery for those injuries?
Objection, Your Honor. If I may be heard.
You may.
This testimony is irrelevant. Defense counsel has stipulated prior to trial that today's trial is in fact bifurcated. Today, we're only talking about liability. We're not talking about damages. And therefore, getting into this testimony, the extent of her injury, whether or not she needed to go to the hospital, that's irrelevant for the jury to hear to determine liability.
Your Honor, may I be heard?
Briefly.
The members of the jury have already heard this information that she fell on her right knee and she was in excruciating pain. They need to hear the extent of the damage so that way they could decide for the damages section in the negligence requirement. Therefore, we do ask for leeway to be able to ask this witness about the surgery, and we are okay with limiting it to the surgery.
Brief response and then I'll rule.
Your Honor, it's not up to counsel to decide what is admissible under today. And nowhere in those jury instructions is the jury going to find anything about injury. We've heard enough testimony today to satisfy that requirement, and counsel does not have to go any further because that would be in violation of a stipulation that defense counsel has already agreed to prior to trial.
I'm going to let you ask her what the final result of her injuries were. I don't want you to get into details of surgery. I don't want you to get into details of anything else, but I'll let you ask one more question and then we'll move on.
Yes, Your Honor. Ms. Gilmore, what was the final result of your injury?
I had to have total knee replacement. It left me with this really ugly scar, and it still hurts, and I still feel a little numb. And, since then, my leg has felt a little bit weak and it's been so hard to get around.
Well, did you ever tell anyone in Chime's management about what happened?
Absolutely. I told my manager, Lane Kim.
How'd your manager respond?
The response I got was, they were like, we should have gotten those steps fixed a long time ago. And, apparently there had been discussions with the owners and about it a few times, but, they apparently had bigger things to worry about.
Thank you, Ms. Gilmore. Your Honor, no further questions at this time.
Bear with me 1 second, counsel, before you start.
Yes, Your Honor.
All right, you may proceed with cross-examination, counsel, whenever you're ready.
Yes, Your Honor. Thank you. Good afternoon, Ms. Gilmore.
Yeah.
You worked at Chimes for about 10 years. Isn't that right?
Correct.
And during those 10 years, you became familiar with the company.
Correct.
You became familiar with the company's policies.
I mean, to the extent, as far as what we were told.
So that's a yes, you did become familiar with your company's policies.
I just knew all of the policies that they would tell us about.
Okay, so we could agree that you were familiar with the policies that related to you as an employee, right?
Sure.
And you were also familiar with the space that you worked in.
Yes.
So I want to talk a little bit about that space. So usually you would work in the front of the store, right?
Yes, I was a cashier.
But sometimes you would have to go to the back of the store.
Yes.
And in the back of the store, there's an exit.
Yes.
And that exit, it leads you to a loading dock.
It does.
And that loading dock has a couple of steps, right?
That is correct.
And those steps, they lead you to a dumpster.
Yes.
Now, sometimes you would have to take those steps to take the trash out.
Yes.
But other times you took those steps to take smoke breaks, right?
Yes.
Now, you couldn't smoke inside the store, right?
Oh no, that was against Chimes's policy.
Exactly. You had to smoke outside the back of the store, right?
Right.
And you'd agree with me that you would go out sometimes to that loading dock about 20 times every single week you worked there, right?
Yes.
And before your accident, every time you went out there, you had never fallen down those stairs, had you?
Thank goodness that hadn't happened before. Just that one time was enough. And oh my goodness.
Miss Gilmore, I'm not asking you about whether that one time was enough. I'm just asking you whether before your accident, you had never fallen down those stairs. And you hadn't, had you?
No, but this time I did. And I was, oh my goodness, this one time, I fell once and the unimaginable pain and, just, it's been so hard to get around since then.
Thank you for that, Miss Gilmore, but I'm going to ask you to focus clearly on what I'm asking you, and I'm looking for a yes or no. But before your accident, you had never fallen down those stairs. Yes?
I had never fallen, just this one time.
Okay. And you had never had an accident near that loading area. Isn't that right?
Yes, that's correct.
So let's shift gears and talk about the night of the accident. So on January 23rd, 2019, you go out for a smoke break, right?
Yes.
And it's around 7 p.m.
Yes.
And you're with one of your coworkers, right?
Yes, with Riley.
And when you're on your break, it's dark outside.
Yes.
So to take your break, you knew that you would have to go to the back of the store, right?
I did.
So let's take a look at the back of the store one more time. Ms. Barrett, could you pull up for us what has been already admitted as Exhibit 2? Okay, so this is a picture of the back of the store, right?
Yes.
And that's where you fell.
Yes.
And the night that you went out there, the night of your accident, it was dark outside, right?
Yes.
Now, before you went outside that night, you knew there was no railing near the landing, right?
Right. There was no railing.
Right. And you knew there was no railing near those steps.
I think, yes. And, I think that was something that should have been up to Chimes.
Miss Gilmore, I'm not asking whether or not you thought that was up to Chimes. I'm just asking whether or not you knew there was no railing near those steps. And there was no railing, right?
Right. There was no railing.
You also knew that you could not turn that light on outside, right?
Yes, and we had told we had told Chimes about it countless times, and they didn't listen to us about the fact that there was no light.
Miss Gilmore, again, I'm asking you to listen to my questions real close, and I'm just looking for a yes or no answer. And it's true that you knew that you could not turn that light on out there before you went out there that night, right?
Right.
Okay. So I want to look at another picture of those stairs. Miss Bayer, could you pull up what has been already admitted as Exhibit 4? So this is the same stairs that we just looked at, right?
Yes.
And before you went outside that night, you knew that there was that loose concrete on the steps, right?
I mean, I just knew that, to get down, I just needed to take those stairs.
Well, you knew that those stairs were in that condition, correct?
I mean, I just know about those stairs, like, daily scope, but yes.
Ms. Gilmore, so that's a yes to my question?
Yes.
Okay, and you also knew that there was that hole with the exposed pipe, right?
I guess so.
Okay, so knowing all this, knowing what the stairs looked like, you went outside anyway, correct?
Yes.
You had Riley prop the door open just like this.
Yes.
You went down the stairs.
Yes.
Took your break.
I did.
And then you started coming back up those steps, right?
I did, yes.
And as you were coming back up the steps, that door, it was still propped open just like this.
I mean, Riley was holding it open, and it was being January, it was windy that night. And
okay, Miss Gilmore, I'm not asking you whether or not it was windy, but on direct examination, you told us that that's how much space you had to step onto that landing. Isn't that right?
Yes.
In fact, when you came up to that landing, you put your right foot right in that little area that's next to the door, correct?
Correct.
And I'm going to put a circle right in that area. And that accurately reflects where you put your foot, right?
Yes, it does. And that's, and I slipped, and, I fell. And
now, before you fell, as you went up those steps, you didn't shine a flashlight so you could see those steps, did you?
I didn't think we were going to be, I was only going to be there, for just a little bit, not that long. I didn't think it wasn't even, we weren't out there, not even not that long. It was
Miss Gilmore.
Almost.
Miss Gilmore, I'm not asking you how long you were going to be out there. I'm asking whether you shined a flashlight as you went up those steps. And you didn't do that, did you?
No, I did not. But it's also because I didn't think I was going to be out there that long.
Well, thank you, but I'm just looking for a yes or no. And it's a yes, you did not shine a flashlight onto those steps, right?
I did not.
And you didn't go to the front of the store to use that front entrance either.
I mean, again, Chimes instructed us, we weren't allowed to smoke outside in the front. We were told that we were only allowed to smoke in the back.
Right, but when you were finished smoking, you could have gone into the front, right?
Yes.
And when you made your way up those steps, you didn't move that door, did you?
I mean, that's because Riley was holding the door. And again,
Miss Gilmore, I'm not asking you whether Riley was holding the door. I'm asking whether you moved that door out of the way, and you didn't do that, did you?
Correct. I couldn't because Riley was holding the door.
But you didn't ask Riley to move the door for you, did you?
No, I did not.
Thank you, Miss Gilmore. Your Honor, I pass the witness.
Can you redirect?
No redirect, Your Honor. May this witness be excused?
She may be excused. You are excused. Call your next witness.
Your Honor, by way of deposition, the plaintiff calls Kelly Danes. And I'd like to request permission for my co-counsel to read the deposition along with me.
You may, he may participate, and since he will be talking, we want to make sure he's on camera. Okay, so question and answer for him. Will he be the witness?
He will be the witness, Your Honor, and I will be reading the questions.
All right. You may proceed whenever you're ready.
Starting on page 2, line 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Tell us about your education.
I have a Bachelor's of Science in Mechanical Engineering from the University of Wisconsin-Madison.
Since graduating from college with your mechanical engineering degree, have you gotten any further education?
Sure. I've attended various seminars offered by the National Academy of Forensic Engineers. I took the courses to become a certified person builder from the Scaffold Training Institute, and I took the requisite courses to become certified in ASME B31.3 process piping design from the American Society of Mechanical Engineers. So basically some continuing education and additional certifications.
I noticed that your CV lists you as a PE. What is that?
It stands for Professional Engineer.
Continuing on page 3, line 2, what do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the Fundamentals of Engineering exam, which I did. Then you have to work as an engineer for 4 years before you take the Professional Engineering exam. So I took that as well, and I passed.
What do you do professionally?
I'm the president of Danes Engineering, LLC.
What does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Continuing on to page 4, line 5. Do you testify mostly for plaintiffs or defendants?
Both. Pretty even, really.
Over the course of your career, how many incidents have you investigated?
Over 60.
And how many times have you testified at trial?
Twice prior to this.
Page 5, line 14. All right, Kelly, I want to move on and talk about your work in this case. What did you review in coming to your opinions in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fault and took pictures of that area.
Your Honor, at this time, the plaintiff tenders Mr. Kelly Danes as an expert in mechanical engineering and safety regulations.
Any objection?
Yes, Your Honor. This witness is not qualified to be an expert in safety regulations specifically. We have no problem with this expert being tendered as a mechanical engineer, as his CV definitely reflects that. However, under Rule 702, he does not have the specialized knowledge required to be an expert in safety regulations.
Your Honor, may I be heard on those grounds?
You may.
Under Rule 702, an expert must assist the fact finder in understanding their testimony. Now, pursuant to Mr. Danes' expertise, he testified that he regularly works in the field looking at different safety regulations and making sure that individuals are following those safety regulations, as well as the fact that he has passed numerous exams regarding engineering of these industrial areas and areas that are like the one at issue in this case. And therefore, pursuant to Federal Rule of Evidence 702, he can assist the fact finder in understanding the testimony.
Your Honor, if I may briefly respond.
Very briefly.
The expert testified that he can provide forensic and investigative engineering consulting and litigation support. Nowhere in his testimony did he specifically say that he's familiar with any types of safety regulations. Saying that he's participated in litigations like this one does not mean that they all had the same types of issues. And therefore does not have any specialized knowledge that opposing counsel can specifically point to.
I'm going to receive him. The area of dispute can be explored on cross-examination. That'll go more to the weight. I'm going to allow him to testify.
Yes, Your Honor.
Your Honor, moving on to page 5, lines 14. All right, Kelly, I want to move on and talk about your work in this case. What did you review in coming to your opinions in this case? Oh, I apologize. You're muted.
Apologies. I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Moving on to page 6, line 14. Are exhibits 16 through 21 fair and accurate depictions of how that area looked at the time of Jordan Gilmore's fall?
Yes. Well, it was dark when he fell, but other than that, this is the same area and how it looked.
And what do those pictures show?
Well, as you can see, there are no railings on the steps up to that landing area, and there's no railing on that landing area itself. Plus, you can see where the railing used to go in the concrete and how the concrete around those areas is worn down and cracked. So you can see that this is a pretty dangerous situation.
Moving on to page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and landing in question, and the facilities in question must be in compliance with those codes and regulations.
Moving on to page 9, line 9. All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found at 29 USCS section 654, and the maintenance provision under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and/or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards. So fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
On page 11, line 6. What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37b1 and IBC 1006.1, which both deal with lighting.
Why are those significant?
Well, 1910.37b requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs, but there was no switch for that light inside the chime store. So there was no way for the employees to turn that light on when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
Page 11, line 24. What's next?
Next, we move to OSHA 1910.23d1 and 1910.24h and IBC 1009.11.
Why are these significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
I'm showing you what has been marked as Exhibit 34. Do you recognize this?
Yes, that is a photograph of the back of the building taken around the year 2000, back when that entire building was a Walmart and before Chimes was a tenant. And as you can see, there is a guardrail on that set of stairs and railing, so it must have been removed at some point.
Is Exhibit 34 a fair and accurate depiction of the outside of the back of that building as it appeared in the year 2000?
Yes, it is.
Your Honor, plaintiff moves Exhibit 34 into evidence.
I have not seen 34, counsel.
Your Honor, would you like me to screen share with Exhibit 34?
Yes.
Mr. Patel, will you please share Exhibit 34?
And just so you'll know, counsel, I stopped the clock a little bit to allow your counsel to use the technology, so you're not being docked for this.
Thank you, Your Honor. We love technology, so that's always fun.
Okay.
Are you able to see that okay, Your Honor?
I'm able to see it. Any objections to plaintiffs or to Exhibit 34 by defense?
No objections, Your Honor.
Okay, 34 will be received.
Continuing on to page 15, line 7. Any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have easily been fixed by putting up a guardrail around those stairs and landing and patching the cracked concrete on those steps. It would have been easy. And if the defendant had taken these simple steps, putting up a guardrail along the stairs, putting a guardrail around that landing, making sure that—
Objection, Your Honor. To 403, may I be heard?
You may.
Right now, the witness is speculating as to what would have happened if the defendant did put a guardrail along those stairs. This witness has no way of knowing of whether someone could have even slipped if the guardrail was there. They could have gotten hurt in some other way. Therefore, for them to speculate purely on what would have definitely happened if they put a guardrail there, that's going to mislead the jury today, and it is, and that's inadmissible under Rule 403.
Response.
Your Honor, may I be heard? Your Honor, opposing counsel's objection goes to the weight, not the admissibility of this evidence. This witness is an expert witness whose job it is to list out what the possible fixes could have been in this case. And therefore, Mr. Daines is allowed to testify as to what the fixes would have been and what the results would have been as well.
The result of the fixes, or is the result of— You said, and the result of what?
Yes, Your Honor. The results that once the fix is taken, it's the result of that fix and how it would have changed the issue in this case.
Your Honor, if I may.
I'm going to allow the expert to testify as far as the conditions, as far as what should have been done. I'm not going to allow him to testify what would have happened one way or the other. He can testify as far as what should have been done and what wasn't done.
Yes, Your Honor. Would you like me to redact that portion as the witness is reading, as my co-counsel is reading the answer?
We will, for the judge's benefit, we will constructively redact it so you don't have to specifically redact it. I'll let you read it with the understanding that that portion would not have been heard by the jury.
Yes, Your Honor. Line 7, any final thoughts?
Honestly, I just don't know what the defendant was doing here. All of this could have easily been fixed by putting up a guardrail around those steps and landing and patching the cracked concrete on those steps. It would have been easy.
Please continue, Mr. Patel.
And if the defendant had taken those simple steps, putting a guardrail along those stairs, putting a guardrail around that landing, making sure it was well lit, patching the concrete, then the plaintiff's fault would not have happened.
Your Honor, that concludes our reading of this witness's deposition.
Your Honor, just to be clear, as a point of order, it was that last chunk, that last sentence, that's what was redacted, right?
Correct.
Perfect.
Correct.
All right.
From the gist, to be clear, after he said what should have been done, then when he kind of reiterated and said nothing would have happened if he'd have done it. That's the part that's redacted.
All right. Thank you, Your Honor.
Okay, hang on one second.
Yes, Your Honor.
All right, do you have cross on this deposition you're going to read in?
Yes, Your Honor. Is it all right if Ms. Bayer acts as the witness and I read the questions as well?
Absolutely, same way.
All right, starting on page 9, line 4. Do you know or have any opinion on who was responsible for the maintenance and repair of these steps behind the Chime store?
No, that's not what I was asked to do.
Going to page 10, line 4. Let me ask you this. If Chimes wasn't responsible for maintaining that area where the stairs were located in the back of the store, would the IBC apply to Chimes in regards to that area?
No, it wouldn't. The IBC applies to whoever has the responsibility to maintain that area, but the OSHA regulations apply to employers generally, so it's a bit different.
Skipping down on that same page to line 19, do the OSHA regulations place any requirement on employees?
Yes, there's a general duty requirement in 29 USCS section 654B, which says that employees also have to comply with the OSHA standards and regulations and basically have to be responsible for their own actions.
Thank you. Your Honor, we have no further portions of the deposition that we'd like to read onto the record.
Okay, plaintiff, any more witnesses?
Your Honor, with that, the plaintiff rests.
All right. Plaintiff has rested. Defense, any motions?
Yes, Your Honor. At this time, defense moves for a judgment as a matter of law pursuant to Federal Rule of Civil Procedure 50, as even considering all of the evidence in the light most favorable to the plaintiff, they have failed to meet their burden of proof today. Now, the defense would argue that the plaintiff has failed to meet all of their elements, but specifically the first element, that the conditions of the stairs posed an unreasonable risk of harm, and the third element, that Chimes department store failed to exercise ordinary care to protect Jordan Gilmore from the danger. While the plaintiff has attempted to paint the conditions of the loading dock as dangerous today, we have actually heard testimony that there was a light above this loading dock, that there was light coming out of the store, and there were only a couple of stairs, and that the plaintiff had walked down those stairs hundreds of times, 20 times a week without any trouble prior to this incident. We haven't heard any testimony that the condition of the stairs, even if you accept the plaintiff's version of those stairs, posed an unreasonable risk of harm. And we also haven't heard any testimony that Chimes did not act with ordinary care to keep their employees safe. Because we haven't heard any of that testimony establishing that Chimes violated that standard of care, no reasonable jury could find for the plaintiff.
Response?
Your Honor, let's take those 2 points one at a time. First, the unreasonable risk of harm. Viewing the evidence in the light most favorable to the non-moving party, which is the plaintiff in this motion, a reasonable juror could find that the defendant was negligent and created an unreasonable risk of harm. Today, we heard from both the plaintiff as well as our expert witness, Kelly Danes, that there are certain things that the defendant did that fell below the standard of care and were an unreasonable risk of harm. First, we heard that the lighting outside of the loading dock was inappropriate. The members of the jury heard that the switch for this light was actually located in a completely different building with a completely different business. A reasonable employer would not do that, especially given the fact that they sent out a memorandum forcing their employees to go outside to this loading dock area at night to take their breaks. Further, Your Honor, the members of the jury also heard that the concrete on those stairs were jagged and shattered, and therefore the defendant should have taken precautions as mentioned by Kelly Danes under a variety of regulations under OSHA as well as the IBC to fix those issues. Further, Your Honor, moving on to the standard of ordinary care. The members of the jury can decide that the defendant failed to uphold that standard because the OSHA regulations that you heard about apply directly to employers. They give employers the duty to take care of these areas where their employees work, which includes the loading dock in this case. Therefore, we request that you deny this motion.
All right, with that very good argument, both of you, the motion will be denied. Do you, and this goes to the scoring judges as well. Does anybody need a 5-minute break before we start the case for the defense?
A 5-minute break would be great, Your Honor. And if we could also get a time check just so that we can make any necessary adjustments.
I was going to give that to you before I let you go, but
Perfect.
I wanted to see if we need to break. Plaintiff, you have 23 minutes remaining. Defendant, you have 36 minutes and 13 seconds remaining.
Thank you, Your Honor.
All right, we will take 5 minutes. See you guys back at 4:15.
Thank you, Your Honor.
Before everybody runs off, is anybody else getting an echo on the audio? I'm hearing everything about a second on once and then on a second delay, so I may need to leave and get back in if nobody else is.
You might, why don't you jump out and rejoin us and I'll let you in.
Okay, sounds good.
Yeah, I haven't noticed anything.
I haven't either.
Jason, are you back in?
I am, and that echo's gone.
Good.
All right, thank y'all.
Okay, we are back. Do we have all of our scoring judges back? If you would make an appearance. Thank you. Thank you. Thank you. Is Kelsey?
Yes, can you see me?
Can't see you, but I can hear you.
Okay, that's fine.
Which is good enough. As long as you're here, we're good. Okay. We are back on the record, called the case. We are ready to start the defendant's case in chief. So with that, defense counsel, you may call your first witness.
Yes, Your Honor. At this time, defense calls Mr. Reese Geller to the stand.
Mr. Geller, if you would make your appearance, thank you. You have been duly sworn. You may proceed whenever you're ready, counsel.
Yes, Your Honor. Good afternoon.
Good afternoon. Can you hear me and see me okay?
Yes, we can. Could you please state your name for the court?
Hi, I'm Reese Geller.
What do you do for a living, Mr. Geller?
I'm the proud owner of the Chimes department store.
And where is Chimes Department Store located?
So now we're on Bosque Avenue.
How long have you been with Chimes Department Store?
It's been just about feels like it's been my whole life. The company was started by my grandparents, and then my parents took it over. And as soon as I was done with college, I started working there before I ended up taking it over. So quite a while now.
So how long have you been the owner of the store?
I took over as the owner 10 years ago.
Now, has Chimes Department Store always been on Bosque Avenue?
No, we didn't move there till 2005.
Did you have to sign a lease to move into that building?
We did.
Would you recognize a copy of that lease if I showed it to you today?
I would.
Ms. Bayer, could you please share your screen with what has already been admitted into evidence as Exhibit 11? Mr. Geller, can you see that okay?
Yes.
What are we showing you?
This is the lease for our store.
Now, I'm going to direct your attention to the first page of that lease, section 1.10. Do you see where it says demised premises?
Yes.
What's your understanding of that term?
So the demised premises are the part of the store that we are in control of, the part of the property that we are leasing.
And who's responsible for maintaining the demised premises?
That would be Chimes.
Now, where in the lease did it say that you were responsible for maintaining that demised premises?
I believe it's section 8.2 of the lease.
Let's flip to that section right here. Can you read the first sentence of section 8.2 for the members of the jury?
Yes, ma'am. It says, tenant shall keep the demised premises in good, clean, and habitable condition, and shall, at its sole cost and expense, keep the demised premises free of insects, rodents, vermin, and other pests, and make all needed repairs and replacements, including replacement of cracked or broken glass, except for repairs and replacements required to be made by a landlord under the provisions of section 7.4, 8.1, article 14, and article 15.
That's great, Mr. Geller. Thank you. Now, was the landlord responsible for any of the maintenance under the lease?
Yes, the landlord was responsible for the common areas.
And do you know where in the lease it says that?
I believe that part is section 6.3.
Let's pull that section up. Could you tell us what that section says?
Yes, it says landlord shall be responsible for the good and safe operation, management, and maintenance of the common area, and landlord shall operate, manage, and maintain the common area in good, attractive, and safe condition during the lease term.
Did the lease say what areas are included as common areas?
Objection, Your Honor. Calls for legal opinion. May I be heard?
Very briefly.
Your Honor, opposing counsel is asking this witness to opine as to the meaning of certain words in this contract. That is asking to opine as to what they mean and therefore is a legal opinion. Opposing counsel can ask what it meant to this witness, but cannot ask him to testify as an expert to the jury.
Your Honor, if I may.
No, you may not. I don't need to, no offense, but I don't need to hear from you. I don't think the question asked for him to opine. I think the question was straightforward. Does the lease say what is the common areas? If he starts to opine, I would expect that you would object at that point in time. But the question is asked was not improper. It's going to be overruled.
Mr. Geller, do you need me to repeat the question for you?
Yes, please.
Okay. Did the lease say what areas are included as common areas?
It did, and I believe that was section 6.1.
Can you tell us what that section says?
Yes, it says the term common area is defined for all purposes of this lease as that part of the shopping center intended for the common use of all tenants, including among other facilities, such as such may be applicable to the shopping center. And then it provides a long list of examples such as parking areas, landscaping, loading areas, lighting facilities, and so on.
I'm going to focus in on one of the terms you just said. What is a loading area?
So a loading area is something that we as a store, that would be an area that we are unloading or loading trucks to move product.
And how could you be sure you knew what area was included in the demised premises?
Well, we got a map when we signed the lease.
Would you recognize that map if I showed it to you?
I would.
Your Honor, at this time, Ms. Bayer is going to share her screen with what has been already admitted as Exhibit 12.
12 may be shown.
Thank you, Your Honor. Thank you, Ms. Bayer. Mr. Geller, could you tell the members of the jury what this document is?
Yes, so this is a rough map of the shopping center that shows where the common areas are and the demised premises.
And how did you use this map to determine which areas you were responsible for?
Yeah, so we marked on this map with those lines where the demised premises are. So Chimes, for example, has all those lines through it because that's our demised premises.
What's that red X indicate on the map?
That red X indicates where the loading area is.
Now, was the loading area in the demised premises or was it in a common area?
It was in a common area. That's why there's no lines through it.
Thank you, Ms. Bayer. You can stop sharing your screen. I want to shift gears here and talk about the plaintiff in this case. Do you know Jordan Gilmore?
I do.
How do you know her?
Well, she used to work for me at Chimes.
Were you in court today when Ms. Gilmore testified?
Yes, I was.
And did you hear Ms. Gilmore say that she fell off the back stairs at your store?
Yes, I did.
Do you know what back store she's talking about?
Yes, she's referring to the loading dock.
Who was in charge of maintaining that loading dock?
So that was where that red X was that we just saw, the loading area, which is a common area.
So since it's a common area, who's responsible for it?
That would be the landlord, Kermit Realty.
Well, is there someone at your company who is in charge of inspecting the dock?
No, that's just Kermit Realty.
Do your employees ever use that dock?
Sure, we use it every day. It's used for, that's where we have our trash bin. So people take trash out there. People will have their smoke breaks out there. And then since it is a loading dock, we use it every day to take merchandise from the trucks into the store.
What, if anything, did you tell your employees about using the loading dock?
I asked them to be safe whenever they were using it and keep an eye out for any safety issues.
And if there were any safety issues, what, if anything, were your employees supposed to do?
To let me know.
Now, did Miss Gilmore ever report a problem with the loading dock prior to the fall?
Not that I can remember.
Was there a light on the loading dock at the time of the incident?
Yes, there was.
And who controlled that light?
So the light switch for that light was in one of the stores next to us. So the owner of that store controlled it.
Was that light in a common area?
The light itself was, yes.
Did you hear earlier today when Miss Gilmore testified that she fell walking around the door on that loading dock?
Yeah.
And did you hear her testify that the door was propped open?
Yes.
Mr. Geller, does that door open all the way?
Yeah, so I'm not sure what she was doing by trying to go around the door. You can just pull it all the way and it'll go flat against the wall.
Would you recognize a picture of that door if I showed it to you today?
Yeah.
Your Honor, permission to share my screen with what has been previously marked as Exhibit 6 for identification outside the presence of the jury.
It is constructively outside the presence of the jury. You may share your screen.
Ms. Bayer, thank you, Ms. Bayer. Mr. Gilmore, excuse me, Mr. Geller, do you recognize this document?
Yes, it's a picture of the loading dock.
And have there been any changes made to this photo since the last time you've seen it?
No.
Your Honor, at this time, defense moves into evidence, Defense Exhibit 6.
Any objections to Exhibit 6 as proffered?
No objection, Your Honor.
Exhibit 6 will be received.
Permission to publish, Your Honor?
You may publish it to the jury and use it in testimony as you deem appropriate.
Thank you, Your Honor. Now, Mr. Geller, can you describe what we're looking at for the members of the jury right here?
Yeah, so we're looking at the loading dock and the door is on that loading dock. So as you can see, both doors open up and that door on the left of the screen where the steps are, well, it goes all the way to the wall.
Is there a railing on the loading dock?
There's not.
Has there ever been a railing on that loading dock?
Yes, when we first moved into that store back in 2005, we had a railing, and we asked Current Realty to remove the railing.
And how did you make that request?
My dad, who was running the store at the time, sent an email to Current Realty.
Ms. Bayer, could you share your screen with what has already been admitted as Exhibit 13 into evidence? Thank you. Mr. Geller, what are we looking at right here?
So this is that email that my dad sent Kermit Realty back in 2005 asking for the railing to be removed.
Well, why didn't you just remove the railings yourself?
So because this is part of the common area, it was up to the landlord to remove those railings.
So when the company sent this email, did Kermit tell you that you needed to fix the area on your own?
No, they didn't, because it was their job.
Did they tell you that the loading dock wasn't a part of the common area?
No.
Did they tell you that the loading dock was in your control?
No.
So how did Kermit respond?
Well, they took the railing off.
Thank you, Ms. Bayer. You can stop sharing your screen now. Mr. Geller, were you here when Ms. Gilmore testified about some of the problems with your loading dock?
Yes.
So why didn't you fix those problems yourself?
Well, just as Kermit Realty was the one that removed the railing, they were the one in charge of keeping up with that area. They're the ones that were supposed to inspect it, maintain it, and make sure it was safe. We weren't, it wasn't in our control, so we couldn't make those changes ourselves.
Thank you, Mr. Geller. Your Honor, I have no further questions and pass the witness.
Hang on one second for cross. All right, you may begin cross whenever you deem appropriate.
Your Honor, before cross-examination, we'd like to approach on an issue that you reserved ruling on in pretrial.
You may. You have constructively approached.
Your Honor, during pretrial motions, you reserved your ruling on the motion by the defendant to exclude the addition of a light switch inside of the Chimes department store after the accident to the plaintiff occurred. Now, Your Honor, this witness on direct examination, and I wrote it down exactly, he said that the common areas aren't what we control with regard to the light switch. He said that we couldn't make the switch before that, and therefore, Your Honor, that opens the door under Rule 407 to cross-examination on this issue with the scope of control for the subsequent remedial measure.
Counsel, response?
Your Honor, control of the light switch was not an issue. What's at issue today is control of that light that's outside on that common area. Therefore, if we do hear evidence that's being used to show control, this is an attempt to backdoor otherwise inadmissible evidence. Because here, we're not dealing with an issue of whether or not the light switch itself was in their control. We know that it wasn't. It's all about the loading dock. And counsel here is trying to backdoor in that evidence so that the jury believes that the Chimes department store, they did have control over that outside light when in fact they didn't.
Counsel for plaintiff, I heard the testimony that they didn't control the light and that the light switch was in another tenant's location. And is that what you say opened the door?
Correct, Your Honor. Control is at issue in this case, and one of the problems with the loading dock was the fact that the light was not on. That light is directly above the loading dock, and we heard that that was an issue from our expert witness, Kelly Danes. And therefore, we would like to ask this witness questions on cross-examination regarding why that change wasn't made, because he says he couldn't have made that change. That was up to the realty group.
I don't know. If you want to take this witness briefly on voir dire, I'll allow you to do that. I don't know that I heard what you think you heard, and I may have heard it wrong. But if you want to take this witness briefly on voir dire to establish what you think would make it, or which tells me why it's admissible, I'm happy to let you do that.
Yes, Your Honor.
And I will say, because this is during an offer of proof, that I'm not going to dock you for your time, but I would limit you to a minute of questioning. And then I can hear what you want to say, and then I can rule.
Yes, Your Honor. Now, Mr. Geller, you testified on direct examination that you weren't in charge of the common areas, right?
Correct.
The person or entity that controlled the common areas was your landlord.
Yes, Current Realty.
And in the common area was where a light switch was located, right?
The light switch, no, the light itself was located there, but the light switch was in a different store.
Well, bringing you back to my question, that light switch, it controlled the light that was on top of the loading dock, right?
Yes, the light switch controlled the light.
And therefore, to turn on that light, you would have to go into a different business's building.
Yes.
And after the accident occurred, you actually moved that light switch into your building.
We added a light switch for that, yeah.
So now, today, you can actually control that light.
Now I can turn on that light outside, yes.
You can turn on that light so your employees can walk outside in the dark during their breaks.
They could walk outside during the dark during their breaks before as well.
Well, once they walk outside now, there's going to be a light on, right?
Yeah, there could be.
And Kermit Realty, well, you didn't ask for their permission when you moved that light switch into your store.
No.
You didn't write them an email the same way your father wrote an email about the railings to ask them to move the switch.
No.
You just did it yourself.
Correct.
Your Honor, that concludes our voir dire for this witness.
All right. What I'm going to do is I'm going to allow it for limited purpose. Counsel had argued early on the feasibility was one of the exceptions. And I do think that it does go to some issue of control, albeit I think it's tenuous. I'm going to allow the jury and then we'll consider the instructions afterwards, but I'm going to allow that line of questioning at this time.
Yes, Your Honor.
Okay, you may proceed with cross.
Your Honor, your camera went a little blurry. I just want to make sure that you can still hear me okay.
I can hear you fine. My camera has been doing that a couple times.
All right.
You may proceed.
Mr. Geller, you're here today testifying as the owner of Chimes Department Stores.
Yes, ma'am.
You've owned the store for 10 years now.
Yes, ma'am.
In your own words, you claim you worked your way up to the top of the company, right?
Yeah.
But the company was actually started by your grandparents,
Yeah.
who then handed it to your parents,
Correct.
who then turned over the company to you.
Yeah. After I proved myself working at some of the lower positions, they turned over the reins.
So basically, you worked your way up to the top of a family business.
Yes, ma'am.
Now, today you're denying any responsibility for the injury suffered by Jordan Gilmore
Yes, ma'am.
while she was working at your store.
Yeah.
You believe that Ms. Gilmore should be held accountable
Yes.
for what you consider are her bad choices.
Yes.
Now, you admit that you don't regularly inspect the area around your store to look for safety issues.
No, ma'am. Like I said, those common areas, they're the responsibility of Kermit Realty.
Well, you claim you're not a safety company, right?
Right. We are a department store.
That's right. So instead, you instruct your employees to look out for safety issues.
Yeah, like any good owner, I want to make sure that if my employees see anything that they think might be dangerous, it gets back to me.
Well, that's because you think that's part of their job to do.
Yeah, I can't be everywhere in the store at once. They're going to see a lot more of the store than I am on a daily basis. So it's a lot easier for them to do the reporting.
So you expect them to alert you if they see things that worry them.
Exactly.
But you yourself, you don't actually inspect the area for safety issues.
No, ma'am, I'm trying to run a business.
Well, but if the area they alerted you about was your rear loading dock, you believe that you had no duty to make it safe.
I couldn't. The lease said that it was the under the control of the Kermit Realty.
And you didn't lease the area behind the store, right?
No.
You believe you have no obligation to maintain it.
Right.
Because you claim you don't control it.
Yes, ma'am.
But you do admit using the area.
Yeah.
You said on direct examination you use that area on a daily basis.
Exactly. Yes.
As a loading dock.
Yes.
As a place you require employees to use for smoking breaks.
Yeah, it's one of the options that they have to take a smoke break.
And as the location for your dumpster, right?
Yes.
You mentioned that that's one of the options where they can take their smoking breaks, but it's true that you actually told them to only take their breaks behind the store.
Yes, if they were going to smoke on our premises, that's where we wanted them to do it, was behind the store. But if they wanted to smoke in their car or drive home or something and smoke, they could do that.
So bringing you back to my question regarding the locations at your store, they were only allowed to smoke in the back.
At our store, yes.
Now, going back to the dumpster you mentioned earlier, you chose that loading dock as the location for that dumpster.
Yeah, wouldn't look very good if our store just had a big old dumpster right outside the front doors.
You are the ones who actually ordered that dumpster.
Yeah.
Not Kermit Realty Group.
No.
You determined where it was to be located.
Yeah.
And you required your employees to clean that area up.
Yeah,
You're not aware of anyone else who's ever cleaned that area, right?
no,
Or used that area before?
no,
In the 16 years that you've been at that location.
right, yeah, don't know.
You also knew that under your lease, you could request the landlord to make changes behind your store.
Yeah,
You actually used that process back in 2005 to remove the railings from the stairway.
yes, ma'am.
Mr. Patel, will you please post Exhibit 13? This has already been entered into evidence, Your Honor. Now, on direct examination, you said that in this email, you asked Kermit Realty to remove the railings from the steps, right?
Yes,
And these were the steps that were at the loading dock.
yes,
You wanted to use the area as a loading dock.
yeah, we needed some place to bring in our merchandise from the trucks.
And you agreed to pay the cost to make the change.
Yep,
And ultimately, Kermit Realty made that change.
yeah,
And you reimbursed them for that change.
exactly, yes.
Now, you also made a change to that area after Miss Gilmore's accident.
I'm not sure what you're referring to.
Well, you do remember installing a light switch inside your store,
Yes,
a switch that can control the light in the loading dock area.
yes,
That was a light that your employees could not access on the night of the injury.
no.
You didn't ask. I apologize. Are you finished with your answer?
I was just gonna say the light switch was in that other store.
Well, you didn't ask Kermit Realty to install it, right?
No,
You just did it yourself.
yeah,
So you could control the lighting in that area.
yeah,
But Miss Gilmore, she's not the first employee to be injured in that area.
Objection, Your Honor, to character evidence, if I may be heard.
You may be heard. And do you want to do this in front of the jury, or do you want to be constructively outside the presence of the jury?
If we could be constructively outside the presence of the jury, Your Honor.
I thought you might be making that request. We are constructively outside the presence of the jury. You may be heard.
Your Honor, we have a good faith basis to believe, based on counsel's opening statement, that this testimony is going to be asking about a prior incident where an employee had fallen, had an accident on these steps, and they're going to ask whether or not they fixed that light after they got a report about it. This is character evidence. This is purely propensity that because the company at some point had an accident and the employee reported that they couldn't see anything, they didn't do anything, and that they did the same thing here. And that's not admissible under rule, that's not admissible because it is character evidence.
Counsel?
May I be heard? Your Honor, first of all, under Rule 404 of the Federal Rules of Evidence, this is not character evidence because this is a company defendant. We're not talking about an individual whose character that is at issue. Furthermore, Your Honor, even if somehow a defendant company can have character, Your Honor, this goes to notice. The fact that this injury occurred before put the defendant on notice about the fact that these steps were unsafe. And therefore, Your Honor, this is not character evidence under Rule 404B, and it falls under an exception.
When is this fall supposedly that we're going to hear about? When did it take place?
Your Honor, it takes place 9 years before the injury to Miss Gilmore.
I'm going to sustain the objection. I'm not going to allow you to get into something that was 9 years earlier.
Yes, Your Honor. Now, Mr. Geller, it's your opinion that Miss Gilmore should have pushed that door all the way out when she was walking back into the store, right?
exactly. Yeah, she should have done that.
But to be clear, you don't have a sign out there that says push the door all the way open when you're going back?
No, ma'am. I just think it's kind of common sense that if something's blocking your way up something, instead of trying to go around that, you simply move it.
Well, you don't have a warning sign there that there's a possibility that this door might block the stairway.
No, ma'am. I don't put up a warning sign for everyone to use common sense every time it's applicable.
Well, you also don't train your employees to be careful when using that door, right?
No, ma'am.
No further questions, Your Honor.
Can you redirect?
Yes, Your Honor, briefly. Mr. Geller, on cross-examination, you were asked whether you installed a light switch inside of your store. Per your lease agreement, did you have control over what you did inside of your store?
Inside of my store, yes.
Thank you, Mr. Geller. Your Honor, I have no further questions.
All right, call your next witness.
Your Honor, at this time, defense has no more witnesses and we rest our case in chief.
All right. We have closed the evidence. I'm assuming there's no rebuttal evidence because I don't believe my rules allow you to have rebuttal evidence. Is that correct?
Your Honor, we are allowed to present a rebuttal case.
Okay, well then, do you have a rebuttal case you want to present?
Your Honor, yes, we'd like to read the deposition of a witness in this case, Perry Hayden, who the defense has decided not to call.
All right, this will, I will invite, well, you're keeping track of your time. I'm not keeping track, but you're aware of your time. So you're free to use your time as you deem appropriate. So we will, you may call your witness, your rebuttal witness by deposition.
Yes, Your Honor. May my co-counsel appear on screen to read the deposition with me?
We will use the same procedure we used for the other depositions. Mr. Patel, you're muted. You may proceed.
Your Honor, beginning on page 7, lines 3. Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half of as much of experience as me could look at that and see some pretty obvious problems.
Question: if there were such obvious safety issues, why didn't you issue any citations?
Objection, Your Honor. We have not heard any background as to who this witness is or what their qualifications are. So at this point, hearing this testimony would be improper.
I agree. Since there's been no foundation laid, I will sustain the objection.
Sure, Your Honor. Beginning on page 2, lines 11. What do you do for a living?
I am a compliance, safety, and health officer with the Occupational Safety and Health Administration.
Now, going back to page 7. Question, line 20, question. Mr. Hayden, I'm showing you what has been marked as Exhibit 37. Do you recognize this?
Yes, this is a report from OSHA regarding some proposed regulations.
Is Exhibit 37 a true and correct copy of that OSHA report from May 2nd, 2003?
Yes, it is.
Now, why is this relevant to your opinion about the area in the back of Chimes?
Because in this report, OSHA was interpreting some proposed regulations related to guardrails, and OSHA made it clear that if those regulations would pass, that they would not apply to loading docks. You can see—
Objection, Your Honor. To more prejudicial as it is probative, may I approach?
You may.
Your Honor, hearing this testimony about a proposed regulation and the intent that OSHA had about some proposed regulation is extremely misleading under Rule 403. This regulation was proposed, it never passed. Therefore, hearing it would simply mislead the jury into thinking that it is in fact a regulation that existed at the time that the company had to abide by, when that's not true, because that regulation was never passed.
Your Honor, may I be heard?
what I want you to tell me about is a proposed regulation that was not passed, and from what I understand was 2003. Was that the date?
Yes, Your Honor. Yes.
So address the fact that it was proposed and not a regulation, and that it was a proposal that was made apparently 16 years before the accident. So in your response, address those.
Your Honor, this is a piece of evidence that this witness relied on when coming to their opinions. They use this piece of evidence to opine as to their opinion about whether or not the defendant in this case was liable for the issues relating to the loading dock. Now, under Rule 703, testimony and evidence is admissible if a expert witness relied on it to come to their opinions in this case, and that's exactly what happened here. Though the proposal was not eventually adopted, this witness relied on it nevertheless.
Your Honor, if I may.
You may.
Rule 403 continues to say that the facts and data, their probative value in helping the jury evaluate that opinion has to substantially outweigh their prejudicial effect. And here, the prejudice would be extremely high. You have an expert talking about regulations that were proposed and never passed. Therefore, this would definitely mislead a jury who is hearing about these regulations for the very first time, especially since they're from 2003 and they're not applicable.
Who is this witness again?
Your Honor, this is an OSHA officer.
Right. And he has not been previously tendered by anybody, right?
No, Your Honor, we are just admitting the testimony based on the fact that he is an OSHA officer.
Okay. I'm going to sustain the objection.
Your Honor.
Permission to strike any of that testimony, Your Honor?
I don't know that I really ever heard any of the testimony, but if he rendered opinions regarding a prior proposal from 2003, I'm going to instruct the jury to disregard that.
Yes, Your Honor.
Moving on to page 11, lines 4 through 8. Do you have any opinion about who was in control of that area behind the chimes, whether it was chimes or the landlord?
Nope. That's way outside my bailiwick. I mean, it certainly seemed to me like it was chimes.
Objection, Your Honor. This witness to speculation, if I may be heard.
No, I'm going to sustain that objection. I think the first part of his answer said he doesn't know, and so that would be speculation.
Your Honor, moving on to page 11, line 21. Did you ask the manager about that light?
I did, like you can see in my report.
And what did the manager say?
The manager told me that they always turn the light on when someone goes out back at night. So that seemed good enough for me.
Your Honor, that concludes our reading of this witness's deposition.
Any cross of this witness?
Yes, Your Honor. Starting, is it all right if my co-counsel reads the answers like we did previously?
Absolutely.
All right. Starting with page 8, lines 20 through 20, lines 20. Is there an OSHA regulation that does specifically discuss loading docks?
Yes. 1910.28B13 clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto the dock with a bar in your way.
Skipping to page 9, line 3. Well, what do you have to say about all of the OSHA regulations that Kelly Danes testified were violated by the defendant because of the condition of that landing area on the back of the store?
I'm sure Mr. Danes is a very nice person, but they're just reading those regulations too broadly. None of them deal with loading docks, which is what Chimes was using this area as. This wasn't just a stairwell or just a landing area at the top of a stairwell. This was a loading dock, and the provisions cited by Kelly Danes don't deal with loading docks.
Thank you, Your Honor. With that, we have no more portions of the deposition we would like to read as cross-examination.
Can you redirect out of this on the rebuttal?
No, Your Honor. With that, we rest our rebuttal case.
Okay. The evidence is closed. You rest and close, plaintiff. Is that correct?
Yes, Your Honor.
Defense, you rest and close.
Yes, Your Honor.
All right. We have time check. I have 12 and a half minutes remaining for the plaintiff. I have 23 and a half minutes remaining for the defense. You guys are free to use as much as of your time as you want. I would certainly expect that you would not use 23 and a half minutes in closing. You're certainly free to do that and lose most of the judges if you do, but that's your call.
Yes, Your Honor.
Plaintiff, do you want to reserve some time and do you want me to notify you, or are you going to have co-counsel do that for you?
Your Honor, I'll have my co-counsel notifying me about the time remaining. However, I do want to reserve any remaining time for rebuttal.
It is so reserved. Do you guys need a minute or two to gather yourselves and get ready, or do you want to go right into your closings?
We just like to ask for a quick restroom break and then we're ready.
Okay. We'll give you 5 minutes. Be back here in about 5 minutes.
Thank you, Your Honor.
All right. How many scoring judges do we have?
I'm here, Your Honor.
Okay. Did I hear everybody or see everybody? Did I hear Ms. Warren?
Yeah, yes.
Perfect. All right, so I think that is 1, 2, 3. I think that's everybody back that needs to be back. So counsel, if you're ready to proceed with closing, we will commence with closing argument, and we will first hear from the plaintiff.
Yes, Your Honor. The defendant had no problem with taking risks with the safety of their employees. Force your employees to walk down jagged and cracked steps. No problem. Force your employees to walk down steps that have no guardrails on them. No problem. Force your employees to take their breaks in darkness while they have to go down those very same steps. No problem. But when the inevitable happened, and one of their own employees, Ms. Jordan Gilmore, got injured, now that's a problem for the defendant. The members of the jury, it's not their problem, because they came into court today and they tried to blame everyone and anyone for their decisions. They blamed the landlord, who wasn't even in control of the area that they claimed. And then they actually tried to blame the person whose life that they put at risk. Now, the issue for you to decide today is whether the defendant will finally be held responsible for the dangerous conditions that they made. The judge will tell you that we just had to prove that it was more likely than not that the defendant was negligent. That means that if you put all of the evidence you saw today from the plaintiff on one side, and you put the evidence from the defendant on the other, and that scale tips to our favor ever so slightly, then you must find in favor of the plaintiff. Now, today we met that burden because the evidence has shown 3 things. First, that the defendant knew their loading dock was dangerous. Second, that the defendant didn't fix their dangerous condition. And third, that it was the defendant's negligence that caused Ms. Gilmore's injuries. So let's talk about that first thing the evidence showed, that the defendant knew their loading dock was dangerous. The members of the jury, the judge will tell you that in order to be negligent, the defendant must have not used ordinary care or must have not acted the way a regular employer would have. So how do you know that the defendant didn't use ordinary care? Well, that's because you heard the testimony today from Kelly Danes. You heard how many things were wrong with that loading dock. There was no light for employees to be able to see while they were going down those steps. There were no handrails so that the employees can hold on to them as they walk down the concrete. Well, that was all chipped. You even saw how that concrete was chipped in this photograph. You can see the areas where the defendant ripped those handrails out. You also heard that the loading dock, well, that loading dock didn't have guardrails either. But how can you be sure that the defendant knew about these problems? Well, that's because their employees complained to them about them. But what did they say in response? They said, quote, we have used these stairs a long time, but they should have been fixed a long time ago. We're sorry, we can't do anything else. Those are the statements from the defendant's manager. Members of the jury, that brings me to the second thing the evidence showed, that the defendant did nothing to fix their dangerous condition. So how can you know that this condition wasn't fixed? Well, members of the jury, after they ripped out those rails, they knew that their employees weren't going to have the opportunity to have something to hold on to when they walked down those steps. You know that it wasn't fixed because after giving them notice after employee complaining, They didn't do anything to fix those steps. Members of the jury, today they made a big issue of the fact that Kermit Realty allegedly had control over this area. But remember on cross-examination, how the defendant himself, the owner of Chimes department store, says, oh, we actually use that area behind the store every single day, not just as a loading dock. Members of the jury, that's the words of the owner himself in this trial. He admitted to you that they're not the only ones who control that area. So when they come up here and they try to tell you that, oh, it was Kermit Realty's problem because they're the ones in charge, you know that doesn't make any sense. Because at the end of the day, they were the ones telling their employees to throw away trash there. They were the ones telling their employees, forcing them to take their breaks out in the back. Members of the jury, when you go back to deliberate, you're going to see that your jury instruction actually allows you to decide control, whether it's based on actual control or contractual control. You're going to see that we could have proved that, showing you whether it was under their power under a contract or by the use of that area. And so that brings me to the third thing the evidence has shown, that it was the defendant's negligence that led to Ms. Gilmore's injuries. Now, members of the jury, when Ms. Gilmore testified today, you heard how when she went back to the loading dock area to take her break, she couldn't see anything. That light, the one light that was actually the one that was supposed to be on to illuminate that loading dock, well, the switch for that light was all the way in the other building. Today, you heard how it was only after Miss Gilmore fell that the defendant admits that they had control over that light switch. They tried to tell you that, oh, that light wasn't in our power to change. It wasn't in our power to be able to have that switch with us. But members of the jury, you know that just doesn't make any sense. So when you go back to deliberate, you're going to get this jury charge. And this jury charge is going to ask you one question. Did the negligence of any of those named below proximately cause the occurrence or injury in question? And because you know that Chimes department store was in control of that area, because you know that they used it regularly, not only as a loading dock, but for taking out trash, for employees taking their breaks there, we ask you to write yes next to their name. Members of the jury, because you know the fact that Kermit Realty Group only had contractual control of the area, but the actual use was by the defendant. We ask you to write no next to their name. And finally, members of the jury, because Miss Jordan Gilmore couldn't have added that railing to those stairs herself, because she couldn't have switched that light switch herself, because she couldn't have fixed those cracked steps, we ask you to write no next to her name as well. The defendant took risks with their employees' safety, and now it's time for them to take responsibility for what they did. Return a verdict finding the defendant, and only the defendant, liable. Thank you.
You may, obviously I just said something and I was muted. What I told plaintiff's counsel was she used 3 minutes and 50 seconds, or she has 3 minutes and 40 seconds remaining of her rebuttal time. That's how much is remaining. And counsel for defendant, excuse me, you may proceed at any time you want.
May it please the court. There's a character in this story you didn't hear from today. An important person who had the power to fix the exact problems the plaintiff just told you about. A person who actually had control over the spot where Miss Gilmore hurt her knee. And that's the CEO of the landlord company, Kermit Realty Co. The person who actually owns, actually operates, who actually controls the loading dock that we've heard so much about today. And you didn't hear from them today because the plaintiff wants you to take the easy way out. They want you to really take a look at only the company that's right in front of you and say, well, it must be this company's fault. But when you take a look at it, when you really think about it, when you use your common sense and nothing more, you see that Chimes department store isn't responsible for what happened to the plaintiff. And they aren't responsible because there were two moments in this story that made all the difference. Two moments that had absolutely nothing to do with Chimes department store. Now, throughout today's trial, the plaintiff has told you that time and time again that it was Chimes department store that was negligent in the way they maintained the back of their store. That it was Chimes' fault that the plaintiff got hurt. But they can't just tell you that, members of the jury. They had to prove it to you. They had to prove to you that it was more likely than not that Chimes department store was negligent. But in order to do that, they had to prove that it was Chimes' responsibility to maintain the back of that store in the first place. And you heard that, and you know that they didn't meet their burden today, that they didn't prove that to you. And they didn't prove that to you because we heard about those two moments, members of the jury, those two parties that made all the difference. We heard that it was the landlord, not Chimes, who was in charge of maintaining that loading dock. And we heard that when the plaintiff failed to open the door before stepping onto that dock, well, she caused her fall. Now, here in Texas, if other people are responsible, you as the jury are allowed to find that someone else is responsible for the injury, but the defendant isn't. And if it's someone or something else that caused Miss Gilmore's injuries, well, my client Chimes isn't liable. And we know that that's exactly what happened here. And because we're asking you to find that it was Kermit Realty and the plaintiff who were actually responsible for this fall, we had a burden too. We had to prove to you by a preponderance of the evidence, meaning more likely than not, that what happened here today was the fault of the landlord and the plaintiff herself. And we've met our burden today. We've proved to you that it was the landlord who had control of that loading dock, who failed to adequately warn the plaintiff and make that dock reasonably safe. We've also proved to you that the plaintiff took an unreasonable risk by trying to sneak around the edge of that step when the door was blocking her way. And it was those two things that caused this horrible accident to happen. But Chimes department store was not responsible. That's why when you go back to deliberate in just a few minutes, there are two moments you need to keep in mind. One in 2005, one in 2019. Two moments that made all the difference, two moments that could have prevented that accident from ever happening. So let's walk back together to 2005, back to 16 years ago when Mr. Geller told you that Chimes department store signed a lease. Now, you'll get to look at that lease again when you go back to deliberate, but before you do that, let's look at it together one more time. So you'll get to see Exhibit 11, and you see that this is the lease agreement between Chimes and their landlord, Kermit Realty Group. But what I want you to pay close attention to was the map that came attached to this lease, and that was Exhibit 12. So you'll get to bring that back with you, and this map shows you exactly what parts of the building Chimes gets to control as a part of their agreement under the lease, and which parts of the building the landlord gets to control. Now, when I say control, all that I mean is who's responsible for maintaining that area of the property. You know, who's making sure that it's up to code, making sure that it's safe, making sure that it abides by whatever terms are outlined in that agreement. And if you look real close on that map, the cross-hatched parts, that's what Chimes has control over. Mr. Geller told you that. The blank areas are what the landlord has control over. Now, let's look at that X marked on that map. Well, that's the exact loading dock, the exact spot the plaintiff hurt herself on. Now, the plaintiff claims that Chimes is responsible for that loading dock, but you heard Mr. Geller loud and clear on direct examination, that dock was not the store's responsibility. And we know why. There is no crossed hatched marking in that area on the map. You can see it right there. But that's not the only reason we know that it was the landlord who had control over that loading dock. I want to take a close look at that lease one more time with you, looking at section 6.1. And you'll see that in this section, the landlord was responsible for maintaining all of the common areas and keeping them safe. It's written into the contract right there. And what is a common area, members of the jury? A loading dock, just like the one the plaintiff fell off in this case. We also know the landlord, they never disputed this fact. Mr. Geller told you that back in 2005, Chimes emailed the landlord asking if they could remove those railings to the store, and you'll get to take that email back with you when you go back to deliberate. But why is this email important? Well, it's the response that follows that email, members of the jury, because the landlord responded, they removed those railings. Members of the jury, the landlord's actions spoke just as loud as their words in this case. They didn't say, nope, it's not our job. It's not our responsibility. They just did it. They took ownership of that very loading dock we've been talking about. When the landlord removed those railings, at that moment, the landlord took control of the dock, period. They agreed that it was their job to keep it safe and secure, not Chimes department store. So when that concrete crumbled, members of the jury, and the landlord left that dock with that exposed pipe we saw, it was their job to make sure that it was safe. And they did nothing to make sure that it was a safe area usable to their tenants. Now, the plaintiff tried to tell you that even though the lease is clear, it was the landlord's responsibility, that Chimes should be held liable for what they called actual control of the area. They tried to tell you that by asking their employees to smoke in the back of the building instead of the front, by having them take out the trash, they were exercising control over that loading dock in a way that somehow makes them responsible for maintaining it. But members of the jury, when you go back to that jury deliberation room, you get to take your most powerful tool with you, your common sense. So I want you to use your common sense and think about that argument. Think about a person renting an apartment. Do they exercise control over a commonly shared trash chute? When they walk through the halls and someone gets hurt, are they responsible for that accident? No. Chimes department store had no control over that loading dock. And we've proven that to you today. We've proven to you that it was Kermit who had the control, had the responsibility to take care of that loading dock, and they failed to do it. So let's talk about that second moment. The moment when the plaintiff made a choice that led to her fall. January 23rd, 2019. We've heard a lot about that moment, the fall, today. We've heard the plaintiff is climbing up the stairs, hand on the wall, and when she reaches the top, she meets an obstacle. Her coworker is standing with the door open, making it so there's only inches of space from the edge of the door to the dock. There's only inches of space for the plaintiff to walk through. And instead of doing what a reasonable person would have done, instead of opening that door all the way or asking her coworker to make room, the plaintiff decides to chance it. She takes fate into her own hands and tries to squeeze through an opening she knew she would never make it through. No, we heard from Kelly Danes, the plaintiff's own witness, that the plaintiff, as an employee, had a responsibility for her actions under OSHA regulations. We also heard that those OSHA regulations, they didn't apply to loading docks. So despite what the plaintiff has tried to tell you over and over, we didn't hear today that the plaintiff had no choice but to step around that door. The truth is, we heard the opposite. We heard that there were many other options the plaintiff had. She could have asked her friend to move. She could have used a front entrance, shined a flashlight to illuminate the steps. She could have just opened the door. It's not a problem that the plaintiff tried to take the steps back to work that day, members of the jury. It's how she went about it that matters. A reasonable person would have simply moved that door out of the way and opened it up. A reasonable person would have done that because it's not hard to do. But the plaintiff didn't do that. And because the plaintiff did not do that, members of the jury, because she didn't take that reasonable option, she's responsible for her own actions. Now, the plaintiff's lawyer, she's going to get one more chance to talk to you today. And when she gets up here, listen closely to if she tells you why Chimes should be the party held responsible for those 2 moments they had no control over. And if she tells you why Chimes should be responsible for an area that the landlord, that owner of the shopping center had control over, and when she guarantees that they've showed you enough evidence to meet their burden, remember, it's not up to them to decide if the evidence is enough, members of the jury. It's up to you. Find Chimes department store not liable. Thank you.
Counsel, you may proceed with your rebuttal. You have 3 minutes, 40 seconds left.
Members of the jury, just as I told you, the defendant came up here and gave you even more excuses. First, they tried to blame this on their landlord again, trying to point to a technicality in their contract to say, look, we're not responsible. That's all on them. But think about it, members of the jury. Throughout this entire trial, how many times did you hear of Kermit Realty actually stepping into that loading dock area and doing something with it? Members of the jury, you heard from the owner on the daily. They use this area as a place to take breaks. They use this area as a place to throw out trash. And of course, they use it as a loading dock as well. And another thing, use your common sense. How many stairways have you seen that don't have a railing on it? You heard that even the law under the OSHA regulations requires that those stairs have a railing attached to them. And then when we asked the owner on cross-examination, did you ever go out there to actually check if that area was safe? What was his response? He said, no, ma'am, I'm trying to run a business here. I don't check the area for safety. I leave that onto my employees. Members of the jury, really? The owner of this company, the employer who these employees trust to keep them safe every day, they're pushing this onto their employees? But that just shows you that they didn't care about the injuries to their employees until this lawsuit came around. And then finally, they had the audacity to continue putting the blame on the woman who was injured because of their bad decisions. But remember, members of the jury, they were required under the law to fix those steps. They were required under the law to make sure that there was a guardrail. They were required under the law to make sure that light up there, well, they had to make it work. But it's convenient that today they come here and they try to put all that responsibility on their employees. Enough is enough. Tell them that when they risk safety, they have to take responsibility for their actions. Find the defendant liable. Thank you.
Okay, both of you, very good job. I'm going to ask the scoring judges to get your scores completed and submitted, and then we will know, they'll come in and let me know that you guys did it right and got them in. In the meantime, I'm going to say a couple things to y'all just in general, and then I'm going to invite, once our scoring judges have their scoring duties completed, to share just a few things with you. I'm going to ask both of you, have you all competed in other, I'm assuming you all have competed in other mock trial competitions throughout your law school careers. Are you both 3Ls?
Yes, I am. Yes.
Have you all competed in our Top Gun before?
I've competed as a second chair last year.
Okay. I'm telling you this because the critiques we will give you will be much, much shorter than most of the other law school competition mock trials in which you have participated, and sometimes I have to endure 25 minutes of being told how I would do something versus how you did something. These judges, and we're not going to do that here. I've got a couple thoughts or questions first, and then thoughts. The OSHA regs that y'all talked about, kind of ran through, are those exhibits, potential exhibits that can be used? I don't have the whole packet, so I don't have all the exhibits. So I'm asking from a curiosity standpoint.
Yes, we were given the statutes.
Okay.
They're not marked as exhibits, so they're not in the exhibits at the end of the packet, but they're in the beginning of the packet, so they're there.
Okay. And I can't remember, and the plaintiff's expert references them, right?
Yes.
Okay. The rebuttal witness, the OSHA inspector, did he have, other than, I think he mentioned his name, did he have more than a name? And a title? Did he have any background?
In OSHA regulations.
No, I mean, like, did it say, I've been to school, but been trained to be an OSHA, I've been with OSHA?
Yeah. Yeah.
Okay. All right. Let's do this. Good to see you, Miss Warren.
Hi, how are you?
I'm good. Miss Warren is a former, she has been not in the Top Gun because we're not allowed to let our people be, But Ms. Warren has been in both of your shoes, fortunately for her, in a very live capacity when she competed. Unfortunately for you guys, you're having to do it by Zoom, and that stinks. Particularly the plaintiff's counsel said you'd been second chair, so you actually got to come to Waco a year ago, and you got to sit. No, that's right. Last year was also by Zoom, so that stinks for you twice. That's a shame. Okay, let's do this. If you very briefly, the 4 scoring judges, if each of you would introduce yourself first, so these folks can understand that what they've got is people that actually know what a courtroom is and know what trying cases means and have been in various things versus some of the judges we see in other competitions that have heard of a courtroom once or twice in their lives. And then if you would pick 1 or 2 things, either one good thing, but one specific recommendation, so we can keep this fairly short for them because they've got a lot ahead of them.
I guess
I'll start.
Right.
My name is Kelsey Warren. I was on Dave's mock trial team, like you said, in law school. Learned a lot. I graduated from law school in 2015 and went to work for the Attorney General's office here in Texas, which is always entertaining. I've tried 5 federal jury trials and had 1 Fifth Circuit argument. So I can tell you that mock trial is a lot different than real life, but I think you're both going to be extraordinary lawyers. So congratulations. My one thing that I would give you advice on going forward, at this time, or if I may, Your Honor, if the judge has already kind of signaled to you that it's okay for you to do something, just go ahead and do it. Don't ask for permission because it kind of seems like a crutch that you lean back on, and you can potentially annoy the judge. I'll take a judge that's mad at me any day over a judge that's annoyed by me because they're gonna stay annoyed. They'll get over being angry. So that's my 2 cents. Good job, y'all.
Thank you, Ms. Warren. Who's next?
I guess I'll go. I'm Michael Smith. I do IP litigation up here in my hometown of Marshall. Yeah, we've been in trial a lot lately, 5 weeks out of the last 9. I apologize for butchering your names. Ms. Sahakyan, plaintiff's counsel?
Yes, that's perfect, actually.
Oh, okay, great. Both of y'all did very, very well. You have one side of what I'm going to say to the other side. When you started out, you were more kind of buttoned down and closed in. One of the things that I liked about both of your camera angle is when you got up to argue, you stood up and stood back so we could see your full presentation a little bit more. But the further you got in, the more open you got and the more persuasive and the more expressive you got. And I thought that your tone towards the end was something you ought to try to open with so that you're using more of that variation that clearly you were able to use towards the end. Ms. Piasecki? Piasecki, okay. 2 things. You said in closing, you said use your common sense and nothing else. That I thought that was a potential landmine because if I had been there, I would have jumped up and said, she's telling you to use common sense because she doesn't want you to use the evidence. So we all say use common sense in closing, but just don't say nothing else because that can be used against you. The only thing I would do is on your presentation, when you were in the substantive parts of your presentation, direct and cross and closing, your tone was always just right. But what I noticed is when you did objections, you tended to get kind of argumentative and you were overly, there was more emotion in the objections. And I think you'd be better served by simply very factually getting across your point, which you did the whole rest of the time. But for some reason, when you were making objections, you got kind of argumentative, and I didn't think that served you well. But again, both of y'all did great, and I thoroughly enjoyed the presentations.
Okay, how about Jason?
All right, my name's Jason Fenton. I'm out here in the big old metropolis of Amarillo now. And a big chunk of what I do is actually the defense side of this stuff for Tyson and other meat packers. So This one was fun to watch as opposed to some of the past where I'm completely out of my bailiwick. But I thought both of y'all did great, especially with the peculiarities of Top Gun and not getting your presentation or anything until the night before. Ms. I'm going to destroy it. Sahakian.
You got it. There you go.
I thought you did great with your signposts through your direct and your cross. You did seem to let them go a little bit as you got a little further in. But it made it real easy for me to follow where you're going. One thing, a small critique, the hyperbole sometimes can get us in trouble. A couple of times in opening, you talked about changing her life forever. And then in closing, talked about putting her life at risk. And and maybe it's because I'm on the defense side most of the time, but it just caught me as a little bit of I don't know that I'd go quite that far. I thought you did great. The only other things, and I say this as one that hates this argument because I hate dealing with it, is couple your responsibility issue here with something along the lines of profits over people. How easy and cheap it would have been to take care of that and just hammer that home. Ms. Piaseski? Pretty close? Okay. I thought that your presentation was great as well. To keep things short, I'll stick with the little improvement area. And this is one that I speak personally on because Hunter, who went through practice court with me, can attest that I used to get in trouble a lot because I can get loud and overbearing because I'm just bigger and have a big voice. And especially
that never happened, Jason.
Never. Never got yelled at for that. But especially when you have a witness like Ms. Gilmore, the plaintiff today, who is difficult. By all means, you had to take control over her at some point. But when they're soft and quiet and kind of meek may not be the right word, let her earn coming after her before you actually do. You started off a little bit hot. I tend to do the same thing. In fact, when I get on the direct with certain witnesses, I have a big old, in bold Sharpie at the top, don't be a jerk. And you didn't get to don't be a jerk status, but just keep that in mind because you seem to have the same type of personality that I do. I want to get after them. And you really got to pump the brakes on it until they've earned it. And she definitely earned it at some point. So overall, I think you did great. Both of you did great. Just a couple little things to take forward.
Hunter? All right. First off, great job, everybody. My name is Hunter Oliver. Was in practice court with Jason a while back. Spent a while in Dallas in private practice doing federal and state litigation. And now I'm up in D.C. Doing more regulatory trial work with the U.S. Department of Transportation. So I'll just give a couple of real quick things. The first is from a high level perspective, I thought y'all both did a great job. Objections were really good. I thought you did a really good job in voir dire, especially since you only had like a minute to get that offer in. Really good job there. I was going to say the same thing Jason did about tone, Ms. Piaseski, on the cross, especially for plaintiff. I thought there were a few times you were a little sharp, especially given how soft-spoken she was. And then overall, I would say, I think you could have been a little more sympathetic to her throughout. Like in my view, I mean, there's certain cases where there's contributory negligence that's, over the top and maybe it's okay. I didn't think this was one. I thought it was, closer. And I think you could have been a little more sympathetic at a few points. But it wasn't, it definitely wasn't over the top. I thought that, it was pretty good tone, but there were a few places. Then the only other final thing I would say is, and maybe I'm just biased on this because I practice admin law now, but I thought the administrative law OSHA objections were really good. A small picky thing, regulations, to me, they're more finalized. They're not passed. So I think that if you said the regulation's not finalized yet, that would sound a little more appropriate in context, but maybe that's just me. And then I would emphasize if it's a proposed rule, that the agency has discretion in going to a final rule, as opposed to, not just the fact that it's proposed, but there's actually a discretionary agency, implication in not going to a final rule, which I think is maybe one step beyond the way y'all argued it too. But overall, great job. I'm always amazed how well people do here with only about 24 hours to turn around with these problems.
Thank you.
How much sleep have y'all had in the last 2 days?
Like 10 hours, it's fine.
That's more than enough.
That's a lot.
I
And that's like
know.
over like 3 days. So that's like not a lot. Yep.
Welcome to the world of potential litigation. I'm going to be very brief because they covered most everything. A couple things. To me, and this is the coach coming out in me a little bit, and Miss Warren she'll probably go, yeah. Give me a good concrete theme early on, build it in, and what I mean by theme is not just the 2 points, but tell me why it's important, and then keep it all the way through. Defense had a little bit clearer to me where they were headed. I would start with a good theme, and I don't mean a catchy shtick. I mean something that is whether it's, as Jason said, whether it's put profits and making sure he made money over a simple thing like walking around. The profits over people, the profits over employees, money over safety, whatever it is, and make that a little more crisp and concrete, and then carry it through and end with it. Start with it, end with it, and help tell me why. If I'm going to use, if I'm going to try to, with an expert, use a regulation that I think is important, just having the expert spit it out. If there's some words in there, that's what I was asking about. If you have, because you can have the expert show it on the screen, or you can show it on the screen while the experts, even in a deposition, if they're talking about regulation 86, OSHA Reg 86, you can actually share screen, and while they're reading it, you can talk about 86 if it's something that you ask, may we share it because it's a statute or a regulation or whatever. Something that is visual, particularly in a competition like this. Visual is good because it's right literally in front of us. And as much as we want to see you guys all the time, we're still able to see you on the side, but you're really wanting us to look at what's important on that. And then the other thing is, this is ticky-tack, but it's something, we kept calling it a loading dock, right? What is the defense counsel, what does the lease call it? Calls it a loading area.
Loading area, yeah.
Loading area. If I'm the defendant, or if I'm somebody and I want to use something that's in a lease, either against somebody or for somebody, I'm going to make sure the jury is following me, because you might have a juror going, hey, is a loading area the same thing as a loading dock? I don't know. But if you use the very words and you call it a loading area, then there's no issue. So think about that from both y'all's perspective. And then lastly, if I'm going to call rebuttal and I'm going to do the OSHA guy, part of your problem was there was no predicate, no foundation for any of us to know who the heck is this guy and why is he able even to talk about this. So you got to lay it. If you're going to do it on rebuttal, you still got to lay the foundation and say, this is, who are you? I'm OSHA. I've been with OSHA 28 years, yada, 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 something. So then when you got to the stuff where he was going to try to opine or not opine, we'd at least have some basis for why you're trying to ask him to render these opinions. Still got to come into evidence. Don't assume we know it in the packet, and it's still got to be brought out in evidence to lay the foundation, whether it's direct, whether it's cross, whether it's rebuttal. But other than that, I thought you both did very good. I like the fact that your styles are slightly different, which is good. You guys both seem natural with your style. And my last bit of, and Ms. Warren's also heard this, don't ever let anybody tell you that you've got to be somebody other than yourself. You should always find out what works for you and use that and go with it. And don't try to emulate somebody, or don't try to let somebody tell you you got to be different. Don't. Because you guys both have good presence. Keep that way. Other than that, very good.
On what Dave said, as a female attorney, I feel like it's sort of my responsibility to tell you. I did mock trial in college and in law school, and I spent a very long time hearing you need to be nice, you need to smile. I'm just not that person. Like, I'm just kind of an aggressive person, and it comes off fake when I'm fake nice. And until Dave and Robert Little coached me, they were the first people who really encouraged me to be myself. And I think you both were. So don't ever let those comments just roll off your back. Put them aside. You do you.
All right, good luck to you guys moving forward, and you are released.
Thank you so much, everyone.
Thank
And
you.
judges, thank you guys.
Thanks, Rima. That was fun. Have a good
Good luck,
one.
Paulina.
You too. Bye.
Thank y'all. Take care.
Thanks.